Hello, a very good morning to you and welcome to your most authoritative news analysis show, Newsfile. My name is Samson Ladi Anyanini. Now, call today, Judgment Debts Day on Newsfile, and you wouldn't be wrong. But let me see if I can get you to take it very easy. God reveals to redeem. I guess many of you are quite familiar with this popular scriptural encouragement that follows almost every frightening prophecy told us in church. Prophet A.G. Dr. Benjamin Kumbo of the Church of Ghana Incorporated, I guess maybe we should put international there, sees the obvious. We are heading further deep down the bottomless pit of judgment debts. Unfortunately, he can't save us. So today on Newsfile, Brothers Okujeto, Malik Bako and co. lead us in prayers, earnest prayers, for redemption. Now I've got some very straightforward questions that I need answers to this morning on the Judgment Day, Debts Day edition of the Newsfile. Now I'm asking, first of all, why the serial publications of judgment debts, good or bad? What is the true picture of the debts threatening to collapse our economy? Will it really? And are judgment debts, settlement, or whatever debts you call them, are they really avoidable? And very finally, commission of inquiry, prosecutions, surcharging officials found to have recklessly caused the liability, engaging external solicitors, etc. Which way is the best way forward? That is the most important part for me on this discussion. This is your most authoritative news analysis show, Newsfile, and join us on this emergency prayer session via 1422-1760. That is by text messages. Email newsfile@myjoyonline.com. You are on Joy 99.7 FM and multi-TV, all here in Accra and across the country. You are listening to us on over a dozen of affiliate stations in Egypt and Beijing. You are watching and listening to us at myjoyonline.com or multitvworld.com. I am Samson Ladi Anyanini. Kojo will be here, hopefully, next week. So we get straight to introduce the panel that I have here to do the discussion. And of course, we'll be looking at other matters that have come up in the course of the week. We'll be looking at Martin Amidu's allegations of, collusion, suspicion of collusion, and also refer to court judgment that also has some suspicion of some collusion between state attorneys and some other officials in attempts to, quote-unquote, dupe the state via judgment debts. You are also aware that the Deputy Minister of Information, Samuel Okujeto Ablakwa, has come up for some discussion. He's been accused of bidding for Isofotton. I have to be very careful about that because I've heard some people have difficulty in saying that. But he has denied that. Well, he's actually gotten some other people to come to his defense to say he didn't do any such thing that's been suggested by the former Attorney General, Martin Amidu. You're also aware that Betty Mold-Idrisu, the former AG, was also before the Parliamentary Public Accounts Committee of Parliament, and she had a good day, I guess. She feels so. She had demanded an apology from the committee for damaging her image with some very criminal, insinuating comments. We'll look at all of that if time allows us. And very finally, also, Mr. Yao Osafo Mafo, a former minister in the Kufuor administration, was in court over Woyome. Woyome, is that what has led us or brought us to all of these revelations of judgment debts? He was in court and introduced what he called an interesting letter. I think I'm familiar with that letter anyway. Anyway, so my guest, Abdul Malik Bako Jr., he's managing editor of the New Crusading Guide newspaper. Honorable Samuel Okujeto Ablakwa, he's Deputy Minister of Information. We have Michael Kwe Jr., he's Deputy Regional Secretary of the New Patriotic Party, Accra, and Felix Ofosu Kwache, member, Government Communication Team. Gentlemen, good morning and welcome.
Good morning.
Good morning.
Thank you, and thank you very much for coming. And as I told you earlier, you can join us via text messages. You're welcome. If you have questions, ask them. And I want to start first with the Honourable Minister Samuel Okujeto Ablakwa, and I want us to look at the issues in the three broader compartments that I have attempted to place them, if we are able to do so. Why the serial publications of the judgment debts, good or not? What's the true picture of the debts? And most importantly, the solutions that are being preferred for to stop the bleeding of the economy, as it were. That is a commission of inquiry. There are calls for presidential commission of inquiry. There are calls for prosecutions, surcharging of officials found to have recklessly caused the liability, engaging external solicitors instead of relying solely on the attorneys or the Attorney General. Is a difficult thing for me to say, but it appears that is a suggestion that something is the best way to go. Now, Sami, let's start it from there. Why the publications of the judgment debts?
Well, thank you, Samson. Let me say good morning to our cherished listeners and viewers. I did indicate about 3 weeks ago when we set out to embark on what we call full disclosure on judgment debts, that we are doing this within the larger context of transparency and accountability. It is without a doubt that the issue of judgment debts, settlement debts, compensation claims, general liability has assumed national prominence, and the people of this country want to know exactly what is going on.
And this was prompted by the Woyomi situation.
How do we assess the situation? How have we come to where we are? What are the ingredients of this situation? Do we have a situation where there is collusion going on, there is fraud? Do we have a situation where a lot of these judgment debts could have been avoided? And indeed, that is a position I hold, that a lot of the judgment debts that we are discussing today could have been avoided if public officers had conducted themselves properly, either at the stage of respecting the sanctity of contracts, or even when it comes to payment, whose claim is right or wrong, who has a valid claim or who does not have a valid claim, or whose claim is invalid. Then there is also the issue of the resources of this country. All of these debts we are talking about is the people's taxes. It's not NDC money or MPP money. So there is a need to let the people of this country know the sums involved and what their taxes are being used for, within the larger spirit of transparency and accountability. Now, all of these disclosures does a number of things for our nation. First of all, there is the tendency for these disclosures to lead to reforms in public administration and reforms in the conduct of public officers. Two, these revelations help to bring sunlight. And you recall that the former U.S. Supreme Court Justice Louis Brandeis is the one who said that sunlight is the best disinfectant. So all of these disclosures helps to bring sunlight. Now, when you have a situation where all stakeholders, everybody, all the citizens, the business community, the investor community, knows that this whole phenomenon of judgment debts is public, the people are going to know anyway. Gone are the days where people can abrogate contracts by heart. So you have confidence being restored in the investor community, in the business community, because of all this pettiness and partisanship and sometimes outright bravado, which leads to these public officers just abrogating contracts at will without respecting the sanctity of contracts. Once it's going to come up for public discussion, there's going to be full disclosure. Everybody is going to watch it. Then, unscrupulous people who also want to take advantage of this whole judgment debt scenario or situation where they can just come up with all kinds of claims on the government when they don't even have basis, when there is no merit, would also watch it. Then persons in Attorney General's department and other offices, other institutions, which we are told, the suspicion has been, when you listen to a lot of the commentary, that some people perhaps just like to sit under the cover of darkness and negotiate. And then, as our friends in the NPP put it, they embark on a Wonchendi kind of aftermath. When everybody knows, all the actors knows that, look, these are matters of public nature. They are in the public domain. They will be put out fully. All the full facts will be put out. It would help address that issue, that suspicion, fair or unfair, so that everybody will be guided.
If I may ask at this point, how do you respond to accusations of selective serialization of the judgment debt for political capital? First of all, you brought up the Africa Automobile Limited $1.5 billion claim, and then subsequently you also held a press conference and put out the Isofotton, matter. And there's also, that viewpoint out there that even though you brought them out and it was for a mischief, the goalpost appears to be shifting because you were not fully aware of the facts.
That is inaccurate. When I announced the Africa Automobile case, it was a Daily Graphic interview that I chose to use. Now, in an interview, you can't put out all the facts and release all the documents to the paper. In that interview, it was clear that we will, in the coming days, be making public all the documentations which we had. Since that was the first one, it also allowed us the opportunity to tease out reaction. And as if I knew all the reactions, a dozen of them from the former government officials, as it were, turned out to be a comedy of errors, to be diplomatic. I mean, some of them were outright falsehoods. No contract, the case never went to court. Africa Automobile never served any court processes on government. I mean, this whole claim is fraudulent. It's a concoction. It's a figment of my imagination. When the documents were put out, it became clear that indeed there was a contract. Indeed, the government officials themselves had gone to court on the basis of that contract to make a counterclaim on Africa Automobile. That they breached the contract. Indeed, they had been served notices and so had proceeded to courts and all of that. Then we came to the Isofotton release. That one, we decided to put out all the documentations that were available to us at the time. And again, we have seen very interesting responses. People are beginning to make U-turns out of documents that they have signed, from documents they have signed. They are saying that they later on found some facts which became available to them subsequently. There is no evidence of those facts which they say became available to them, and they have not put it out. But what is clear about all of these revelations are that substantial liability has been incurred by the state.
A very final question to you. The accusation is that these revelations that you made they were targeted either at the opposition New Patriotic Party to embarrass them, or certain individuals within the party. And this is an election year, so political capital.
Well, first of all, Samson, you speak as if we have come to the end of the serializations. Let me announce that what is coming on Monday promises to be exceedingly revealing. So let nobody be under an illusion that we have come to the end of the road. I mean, Monday at 2 p.m. will be a press conference to put out what promises to be an exceedingly revealing part of this whole judgment debt discourse, as an angle, a side, which has not yet been known to worthy sons and daughters of the land.
And how much is involved in this one?
I won't go there.
Because already the humongous amounts that I'm hearing, it's already sending,
all I can
sending
say,
shivers down my spine. That's where are we going? Because it appears that this country is blessed and we are so rich.
Well, Samson,
because we can afford to pay such judgment debts.
All I can say, Samson, is that it is exceedingly revealing when you look at that case, which will be discussed on Monday. But you see, the accusation that all of this is to achieve some political equalization, and that because Woyome went bad, so we want to equalize. Well, first of all, I have a problem with that kind of political mentality. You know, that if I have done wrong, just for the sake of argument, I have done wrong, and then you have also done wrong, I don't have to put it out because my wrong has come out first, or my wrong has been discussed first. So I am bad. There should be an injunction. I am injuncted from discussing yours because mine has come out first. Mine is bad, so don't do that. I think that that kind of political mentality is not helpful. What we are doing is to put out everything. Transparency. There are people who even say that some of these revelations have hurt us. After the U-turns and all the comedy of errors and lies and fabrications and all of that in the AAL matter, our opponents have sought to even distort it and use it against us. They are saying that I said that Africa Automobile is entitled to 1.5 billion. Though I was the first person to put on record that that claim of theirs, we are contesting it, it is outrageous, we don't support it. But what do they say? All their commentators, listen to them. They deliberately discuss this matter as if I put that out and said that AAL is entitled to it. What are the other distortions? They say that we are putting this out because we support companies, that government officers are not interested in protecting the state and the national purse. We are putting this out to support companies. When we put this out, are only putting out the facts and standing by the truth. If you are saying there is no contract, and we believe there is a contract, we had the government that entered into the contract in the case of AL, for example. If we were to say that, oh, because you say let us not support companies, as if in a democracy it is not good to support individuals, collective, institutions. Let's, for the sake of argument, say that we don't want to support companies, so we want to side with you that there is no contract. What does that say about our own integrity? It means that we were engaged in some fraud when we signed contracts with these companies. So it's very difficult to appreciate how our opponents or critics want us to discuss these matters.
The argument is that especially when the matters are pending in court and you are supposed to protect the public purse, as it were, you should not be heard to sound as though you are helping the plaintiff make their case, or those who are making the claims make their case.
Nobody has sounded that way. Indeed, when we put out the AL matter, we said that the claims that they are making are outrageous. We don't agree with them. We disagree with their claims. We don't support it. We are deadlocked in negotiations. I made that point several times on a number of occasions. I made that point very forcefully. Then it is not possible to engage in full disclosure, put out these matters, and then in the same breath you are saying that we are putting this out to support the company. That is not possible. If indeed we wanted to support the companies in these matters, or we had some, if you like, ulterior motive. Ulterior motives don't thrive in sunlight. We will have wanted a certain cover of darkness to permeate over these matters so that we will meet secretly and then, if you like, engage in the underhand dealings that our opponents are talking about.
All right.
But that cannot be the case.
I'll move on to Abdul Malik Kukubako at this point. And it is the same question, and I've heard you elsewhere suggest that you think that the publications, of course, are tainted with mischief.
Yeah. You see, the selective amnesia that drives the serialization, which my brother Sami has led, is so manifest. And that is what has raised questions. Now we are being hinted that yet another one in the series will follow on Monday.
So he says it's an ongoing project.
We are not told of the nature of this particular one that will drop. So I would hold on to the two that has been put out there, at least AAL and Isofotton. And let me tell you why the point that this is part and parcel of a full disclosure is undermined by the selectivity of the documents put out there. Here we are, the recent one. I find it very difficult to mention that. May people forgive me.
The ISO case. You can call it the ISO case.
Many people.
The ISO case.
Isofotton. The ISO case. Thank God for that. Here we are. What was put out there was a Joe Gatti letter after being told that we are in a judgment debt situation of 1.3 million. To buttress that thing, we're giving two letters, one by a Spanish official and the other by Joe Gatti.
And another one by the Agric minister.
Yeah, but I haven't seen that.
Two, actually.
Two mainly that I have encountered with NDC communicators, including my good friend Felix here, putting across. And then the public is invited to interrogate that issue on basis of these two documents. A further search shows that no, there are many other issues, letters, correspondence, documents that come to form a full complement of this matter. And let me give you an example, a very classic one. The Joe Gatti letter dated June 4th, 2008, which was a letter Attorney General had written virtually to his client or to the government. More or less, it wasn't for public consumption, but it was a letter. It has its weight, it has its value. 4 years down the line, this letter is advertised as a basis for showing that indeed there was a breach of contract, and that it meant that those who might have caused financial loss had already been identified by the Joe Gatti letter, and so they were members of the previous administration. We subsequently find out that this same Joe Gatti, as Attorney General, subsequent to the default, the judgment in default, the default judgment, put in a notice for entry of appearance, put in an application to set aside the default judgment. Attached to this application to set aside the default judgment, he had a statement supporting affidavit in support, and also a proposed statement of defense, copies of which I have here. This is my ISO file. I had to chase this file documents because of the documents they had put out there. And to my amazement, I realized that there were all these subsequent processes that occurred in a court of law. And in my candid opinion, the Joe Gatti letter was rendered redundant, moribund, by effect of the processes that had been filed in court under the same Attorney General. So why 4 years later, a government wants to educate us or inform us on a situation? To be fair, if your motive is not to target others selectively, then in putting out the Jogate letter, we ought to have been told that all these processes took place. And indeed, the application to set aside the default judgment filed on 13 November 2008. The court was scheduled to meet 25th November 2008. Nothing happened then. I believe election period and all the things came on board. Okay. But I found out significantly that under this administration, they then filed an application to set aside the default judgment. It looks as if they filed a fresh one instead of continuing from the Jogate one, which was April 8th, 2009. But interestingly, that as a basis to go out of court and settle, the documents I have seen indicates that why they decided, and it's written, these are memos, they are all here. If I'm challenged, then I can read them, was to the effect that because they had discovered, that is the government side, our attorneys, said they had discovered that the plaintiff was in possession of the Jogate letter and that they intended to use the Jogate letter in court. And in view of that, they were recommending a settlement out of court. I was shocked that people who are to protect our legal interest and to defend it were suggesting that in spite of all what had happened before they came in, the mere fact that the plaintiff was in possession of that June 4, 2008 letter was such a serious weapon that we ought to go and do out of court negotiations.
But it could have been such a damning weapon
no, but that even ought to be determined properly. And I'll show you more evidence to see why it was a ridiculous proposition by people defending state interest. Subsequent to all this, do you know, my brother, that as we speak here, there's an appeal pending?
Yes, we've been told about that.
And you know the nature of the appeal? Martin Amidou in 2011 went to court to ask the High Court to vacate its own decision because it said the High Court did not have jurisdiction to sit on the case. And Martin, in doing so, raised constitutional matters like parliamentary approval, all those things. So you know what the High Court said? In May 2012. Please mark the date. In May 2012, the High Court declined jurisdiction. It did not pronounce on the merits of the case. It declined jurisdiction on the basis that the issues are constitutional. So I have no jurisdiction. That's all. And an appeal was filed by the state, this government, which is pending.
Okay, so if it declined jurisdiction, then they would have restarted the process fresh at the High Court, I suppose.
Well, that's them. They filed. I have the documents here.
Yeah.
So it means that in substance, I'm told the lady, the principal state attorney who filed it, unfortunately traveled to the US and has been involved in a motor accident. I'm sure you know. I'm not sure if I should mention the name, but you know. So, but this is an institution. It's not personalities. So if she is out of the way due to an unfortunate incident or accident, I presume that that thing is pending. You see, that is where my worry is. And all these controversies we've been going through is the processes that we've gone about it. Not that judgment debt or payment of judgment debt in itself is incurably bad. In some instances, we are only interrogating the specifics. So I asked myself, what's going on here? In the process, I found other documents. That's why I'm challenging the selectivity. See, this paper, this thing, research and field study into the award and abrogation of a contract between the government of Ghana and Messrs. Isofotton SA, Madrid, Spain. It was put together by a professional group appointed by this very government at a fee. They were paid 130,000 times 4 because they brought 4 copies. Each copy cost $130,000. This group was commissioned in August 2010 to do this work. September 29th, government entered consent judgment, government and the defendant and the plaintiffs. Mark the dates. November 1st, this group presented its report. Then I asked myself, hold on. You've commissioned a group of experts made up of auditors, accountants, and lawyers to give you a report on this matter in August. Before you received your report, you enter a consent judgment in September 29th. The following month, you receive this report that tells you that the group Isofotton has no case. Your own government, too. It's not us. I'm not talking. I could read all the details here. And they gave a series of reasons why they think that Isofotton has no case. It's not government. But you had already gone for consent judgment, which is almost a fatal injury to our case, to our position. I'm not a lawyer, but the lawyers may explain. Now, in view of this, they had to start meeting again. So the Ministry of Agriculture, in its response to this, a copy of the letter I have here, was to the effect that yes, this report appears to have shown that there's a credible basis for us to have defended the case in court. In view of procurement law, so and so and so and all. You know, when you sign a contract, it doesn't become effective until some conditions precedents within have become effective. And there were some conditions precedents in the signed contract that were not fulfilled. So makes the contract ineffective. All that was put together. The Ministry of Agriculture letter was to the effect that, well, it's too late. We are stopped by our conduct because we started paying and all that. So let's go ahead. But let's try, search and locate those who caused it from the beginning and go and prosecute them for willfully causing financial loss to the state. As if that will work that easily in court of law. So I am saying, when I got all these documents, including minutes of the meetings that they attended with the professional group and others, I have all here. Then I said, no, why would the government want to put out documentation in a restrictive and selective manner and invite us to discuss the issue? How would we do an informed discussion? All we'll do is partisan discussion.
But you also acknowledge that Joe Gatti letter was instructive. And that letter, the content, the summary of which was the advice that the action that was being taken by the government then to terminate the contract with Isofotton was injurious to the state. And that was going to get us into debt.
At that point in time, yes. But if you want to do an objective analysis, and you have that letter, and you have the statement of defense, and you have the application to set out default, you have the entry of appearance, you have all, you put it together, and you were to make a judgment, you will say that Joe Gatti as Attorney General, and at that point in time, had revised his position relative to the June 4th letter. So you can't hold it as a gospel
professional group.
It is not,
okay.
It is not on record.
What is not on record?
Yeah, okay.
No, I want to understand my brother. What is not on record?
It's actually a question I was going to ask you. That Joe Gatti's change of mind or change of position as we are being told by him.
You are inferring.
No.
That once you file something,
it's not evident.
When I come back,
it's not evident.
Please, if it's evident in court of law. I have just told you that they entered an appearance. They put in an application to set aside default judgment. They put in an affidavit in support of the application, and they put in a proposed defense.
You know they didn't go back to court?
Why? See, the case was scheduled. No, listen. Okay. The case was scheduled. The case was scheduled to November. Listen, the case. No, let me finish. The case was
2 minutes. Yes.
You know, on 2 occasions they had settlement meetings.
Hold on.
Before we came to power.
Mr. Baku,
I'll respond to all
that pales into insignificance relative to the court processes, which I am saying that even this administration went to court with another application to set aside default judgment. This same government did so April 2009.
It was thrown out.
No, they went to court, and I have it here. They went to court on the basis. I mean, this government, your administration, but our government. indicated that they were only applying to set the default judgment aside because they had agreed to go and settle outside of court. And it was granted. Sure. I have the court thing here. It was granted. And
what would be wrong with that?
And the point, no, you don't get it. The point I'm making is that, and that's why I said, the only reason why they had gone to court this time around to file a fresh application to set aside the default judgment was that, according to them, they had realized that the plaintiff was holding Joe Gatte's letter, that Scott missile, in their opinion. Yeah. And so once the plaintiff had that weapon, we were defenseless. I say it's ridiculous legal thinking.
Mass destruction.
And beyond that, beyond that, the state again went to court now substantively, okay, to ask the High Court to vacate its own decision.
Yes. Yes. Which point?
And the High Court declined jurisdiction. That's that. And an appeal was filed by the same state.
Okay, I get you.
That's the point I'm making. Right. You don't get it.
Okay, I get it. Okay.
Yes.
Thank you very much, Kokubako. Just hold it there.
Very
we are on
misleading
Newsfile on Joy 99.7 FM. You're also watching us on Multi-TV's Joy News channel. And this is Newsfile, your most authoritative news analysis show. And I come to you, Felix. Yeah. Now, from what Kweku is talking about and referring to particularly, and I think you may need to pay attention to that report that was commissioned, that the report was submitted at such a high cost to the state, and the advice was that these guys didn't have a case against us, and yet we have decided to pursue that path.
I will come to that presently, but I need to start from the top. You see, I vehemently contest Kweku's claim that there has been a selective leakage of the payment of their vendors. About a month ago, government made public this document, which catalogs payments that have been made since 2004, at least. Indeed, some of those payments are things that were occasioned by things that were done before the MPP came to power. Yeah. There's a case of Olaji Yusuf, the famous hotel demolition case. There's a case of Mr. Ike Owusu of Kowus Motors and all that. So these matters have been put in a public domain. The public knows that judgment debt precedes the MPP government. It precedes the NDC government, except that the MPP conveniently, in the wake of the Woyome matter, sought to create the impression that the mere payment of judgment debt amounted to corruption. So that is what this statement or this document sought to achieve. Again, the substantive case. You see, it is instructive that Kweku mentions the things that he's mentioned currently. You see, I submit that Joe Gatte's subsequent U-turn and the things that Kweku has outlined are just post facto rationalizations of something that was done in 2006. Samson, the contract between the Ministry of Agric and Isofotton, and also the case involving Isofotton and the Energy Ministry, arose because on or about March 2006, the Ministry of Agric abrogated a contract that they had with Isofotton. At the time that they abrogated the contract, Isofotton had indeed gone a step further in executing the contract by placing an order for materials to engage in a pilot project just to test the feasibility of the project that they were going to embark on, because it was a new project. They were going to use solar powered systems to ensure that we have irrigation in various parts of this country. So it was a novelty, and therefore they needed to pilot it. They had procured equipment and materials for the execution of that job. But most importantly, I would imagine that if you are abrogating a contract with a particular entity, the least that you can do is to communicate to them and telling them in express terms why, irrespective of the fact that you've entered into a valid binding contract with them, you are abrogating it. Again, the reason informing the abrogation must be known before the contract is abrogated. You cannot abrogate a contract and then come 2-3 years down the line to look for a reason why you abrogated it. So whatever reason, whatever defense that the state ought to have had in this case must have been available on or about March when the contract was abrogated. When Joe Gatte wrote his letter, he stated clearly that having examined the documents, he is unable to mount a defense for the Republic of Ghana because he knows that there was a valid subsisting contract that was abrogated. If we went to court, we will lose, and the people will get damages, and he feels that it is better to settle. Joe Gatte tells us that in spite of the fact that he failed to put in a defense for the state, in spite of the fact that Isofotton got a default judgment, he sometime in November got to learn about reasons why the state may have a case. First of all, Joe Gatte, or the Attorney General's department, was involved in the drafting of the contract. They were consulted before Isofotton was given the contract. They perused the contract documents. The protocol that the Spanish government had entered into with the Republic of Ghana was available to the Attorney General's department. They found nothing wrong with the contract, and then they entered into it. Again, it is instructive that after Isofotton sued around October 2008, Joe Gate and the Attorney General's department could not furnish themselves with reasons why the contract was abrogated 2 years before, and only learned about it in November 2008. Now, I've heard him say, indeed, Kweku mentioned that he put in a subsequent defense. It would be interesting for Kweku to tell viewers what the substance of that defense was. What was the defense upon which Joe Gate said he went to court in November after judgment had been awarded in favor of Isofotton? I've heard Joe Gate say...
Is that not what he's already told us?
Yeah, he said that the Spanish government expressed reservations about Isofotton and that Isofotton did not meet a criteria. I've already indicated at the beginning of my submission that that reason must have been available on or about March 2006 to make it valid. Now, it is instructive that
but also, in law, if you forget to plead something and you discover that later, you are at liberty to go to court.
Listen, the defense that Joe Gate, that's what I'm attacking right now. The defense that he says he went to mount after judgment had been given to Isofotton. He says that the Spanish government said they didn't give approval to Isofotton before they were awarded the contract. That reason certainly must have been known to either the Agric Ministry, the Finance Ministry, the Energy Ministry, or the Presidency. These were the four entities that were involved in this whole transaction. But 1 whole month after the contract has been abrogated, the Spanish government, upon a petition that they received from Isofotton, wrote to the relevant Ghanaian agencies, all these agencies involved. The Spanish government wrote to them in a letter dated 21st April 2006, in which they state categorically that they have absolutely no hand in the selection of the companies or approval of the companies. The only criteria that they have is that the company must be Spanish. Once the company is Spanish, they have absolutely no hand in how they are awarded the contract. More significantly, they stated that they were unhappy about the fact that companies that had won contracts with the Ghanaian government were having their contracts abrogated. Indeed, I will read the paragraph to you so that it informs the discussion. This is paragraph 3 of a letter from the Spanish government dated 21st April 2000. It says, I would like, Mr. Minister, and this is to the late Kojo Baredo, to express our surprise and concern with the selection of companies system. We both agree that this selection must be done by the Ghanaian authorities. We have received some complaints from companies which had signed contracts with the Ghanaian sectorial ministries that are not included in your list without providing us any information or justification. I am sure that you agree with me that this is a very unpleasant situation since we are financing these projects. Moreover, this is in sharp contrast with our previous protocol, which did work quite smoothly. So how is it that Joe Gate is telling the people of Ghana today that in March 2001...
Who signed this letter?
It was signed by the Spanish Minister for Tourism or Cooperation. It is addressed to the Ministry of Fisheries, Ministry of Food and Agric, Ministry of all the relevant agencies involved in the protocol. How is it that the Attorney General is telling the people of Ghana that the reason that he only discovered in November 2008, 2 clear years after the contract had been abrogated, that the Spanish government had not given approval to Isofotton, had been shattered by this letter from the Spanish government. The Spanish government says, indeed, no such approval is required. Second, they were even unhappy, displeased with the Ghanaian government that they were abrogating the contract with Isofotton. That's why I told you that what Joe Gate did was a post-facto rationalization. It was to save somebody's skin. Now, you see, this whole judgment death debate, beyond the fact that it has thrown light on the subject.
Assuming without admitting, Felix, a post-facto rationalization, which you mentioned often, if it is done effectively and can inure to your benefits, why don't you take advantage?
No, but the issue is that it will not inure to anybody's benefit. That's why Joe Gate himself did not go to court. He didn't go. He knew that we had no defense. Again, how do you go and tell the judge that because... Listen.
Oh, I'm sorry.
How do you go and tell the judge... Listen. How do you go and tell the judge that the Spanish government says the Isofotton was not qualified to win the contract? And then the Spanish government has a letter 1 whole month after you gave that reason for abrogating the contract, that indeed no such approval was required, and indeed they were unhappy with the abrogation. Certainly you are not going to succeed in court. So you see, it is not enough to say
but
that go to court.
Is it also important that this letter does not specifically make reference to Isofotton?
No, but the only company that had a contract with the government of Ghana at the time was Isofotton. So they could not have been referring to any other entity. It is instructive that Ablakwa and in Katema, who won the contract subsequently, didn't even go through any procurement processes. They didn't even go through any process at all. They were just awarded the contract. But the point I'm making is that it is not enough to say that go to court. when you know that you have done a wrong that is certainly going to lead you into a ditch. That is what Ghanaians must get clearly. So defenses like, oh, why don't you go to court? Why don't you pursue it to its logical conclusion? It will not hold water when you yourself know that what you've done is legal. Again, back to the point about this group that the Energy Ministry, the Attorney General's office.
But take you briefly back to that one. In respect of AAL, for example, the former Attorney General, Martin Amidu, believes that it is not in your domain to be suggesting to the world that, you know, AAL had a contract, and that is in the domain of the court.
How is that in the domain of the court? Listen. In 2000, the NDC government signs a contract with Africa Automobile Limited. We are fully aware of that fact. Our integrity requires us to stick to the truth.
A contract evidenced only by pro forma invoices.
A contract evidenced by a pro forma invoice, which was submitted upon request of the government of Ghana. And then a letter specifically mandating Africa Automobile Limited to bring in the vehicles. And then another letter acknowledging receipt of the first batch of vehicles and reconfirming the order. Second, the Ghanaian government itself wrote to Africa Automobile Limited expressly stating that they were abrogating a contract. The Ghanaian government then goes to court in 2005 and says in express terms that they were seeking to set aside a contract. So if you put this information out, how can you be said to have defended the company? You see, it is important that the integrity of public officials matter to them. They cannot do things in one breath and come in another breath to deny the very same things. I was going to the exhibit that the document that Kweku speaks about, that group, that the Attorney General's Department put together. First of all, who says that if you put a group together, you cannot change your mind subsequently and do what you think will be in the interest of the state? Listen, in any event, Martin Amidu, he attached that group's work. He summarized it in a memo that he forwarded to the Solicitor General, in which he states that indeed he is aware of the work of that group. The group says you don't have a case. Instructively, he himself says that he doesn't think that he's going to review what has been done before. Yet he submitted it in court. It is Exhibit AG9. It was part of his defense.
Can I see?
Sure, it was part of his defense that he took. That's the title of the exhibit AG9.
Yes, an exhibit.
It was part of the defense that Martin Amidu took to court that he sought to set aside the matter with. And the thing was, even the court declined jurisdiction in this matter and subsequently threw it out. But the issue is this, that you cannot go and commit a wrong and seek solace in the court. You will be found out. And Jogate is fully aware of this fact. That's why he didn't go to court. So I will invite Kweku to tell me what Jogate's defense was in November 2008. Then you will see that what Jogate sought to do was, having realized that indeed there were implications for the persons who abrogated this contract, he sought to just put in a file so that it cannot be said.
You are speculating.
I'm not speculating, but listen, Kweku, I have taken the reason Jogate has given. I have told you that reason will not hold water because there is incontrovertible evidence to the contrary.
Can I suggest? Can we pause briefly and have Kweku
give us Jogate's
that part of it?
First
you still have some time.
Sure, absolutely. I'll be willing to do that.
Yeah, once he finds that.
First of all, the notice of entry of appearance was filed on this 13th day of November by the Anam Pearl Kiwumi Serebo, Principal State Attorney.
All right.
Then they put in a motion on notice to set aside default judgment.
All right. And
this was at the same lady, and court to be moved on Tuesday, 25th November 2008.
There's an affidavit to that.
And then attached to this thing is an affidavit in support by one Eric Gansa, law clerk of the Civil Section Registry, Attorney General's Office, Accra, make oath and say as follows, so many things. Then 5, it says that the defendant did not enter appearance to the suit because the defendant was not aware of the service of writ of summons and the statement on claim on him until he was served with a copy of the judgment. That the registry of the Civil Division of the Defendant's Office inadvertently filed the writ of summons and the statement of claim away without forwarding it to the schedule officer, believing that the writ and the statement of claim are the same as filed in respect of suit number BC 23/2009. 6, that I am informed and very believe same to be true that the defendant has a reasonable and genuine defense to the claim of the plaintiff, and that justice will not be served if the plaintiff is allowed to prove damages on the basis of the interlocutory judgment obtained in default of appearance. Fine attached a proposed statement of defense to the suit.
Okay.
And then there's a proposed.
Yeah, that's a
I wanted to go step by step.
Yeah.
And there are a lot of things that he said here. Those are the normal ones, which I think I should skip.
The key ones, yeah.
He says that under Article 26 of the agreement will enter into force when all the formalities reproduced below are fulfilled. 26.1, all approvals by the relevant Ghanaian authorities have been obtained. 26.2, all approvals by the relevant Spanish authorities have been obtained. The FAD loan shall come into force and its funds made available to the contractor on the terms stipulated in this agreement. It goes on and makes a lot of statements. It says, if the agreement between the client and contractor on the final scope of works and training of the project cost must be endorsed by the client or any other institution nominated by the government. If the agreement is not effective within 24 months, all those things, there are a lot. You understand, defendant, most times are...
Okay, so,
but
so
as we understand, all the endorsements have been received.
All
No,
endorsements.
no,
Listen.
no.
Significantly,
The significant points.
There are
The two things, yes.
Approvals from Ghanaian authorities.
Yes.
And
Approvals from
Spanish
Spanish
authorities.
The Ghanaian authorities had signed an agreement with Isofotton. They were fully aware of what approvals must be gotten. But more significantly, the Spanish authorities have stated in clear, unequivocal terms that you don't require any approval beyond the fact that you are selecting Spanish companies. And that that's what they say. That's what they say. The protocol is clear. There is a protocol that was signed between the government of Ghana and the Republic of Ghana.
If it is so nominated in the agreement that you require approval from two places, you ought to acquire them.
Sure. No, but the issue is this, that the approval they speak about is that the company must be Spanish. Beyond that, Isofotton is Spanish. Beyond that, the Spanish authority does not micromanage. They don't determine what sort of approval the company that wins the contract must get. Second, the government of Ghana was fully aware of all these approvals that must be met, and yet entered into a contract with Isofotton. Isofotton had actually gone into execution of the contract. They had procured materials to begin a pilot project.
Sammy,
you understand the point I'm making?
Okay.
Sammy,
Yeah, that is all.
See, now there's evidence that Joe Gatti did indeed go to court. There's evidence. That's
But that's
irrefutable.
after the
But it's
you
always
close
like
the
that.
bridge after the
No.
circumstance.
All right.
It is
How can you-
in law. It is a mischief that can be cured.
But is this
That's,
that-
no? Please.
Why didn't you go to court first? And they obtained a default
Unless-
and they obtained
Unless you're saying
Why
that
did they have
unless you're saying that
two
Joe
settlement
that is
meetings?
not a serious
Joe
question.
Gatti's
to ask.
acting was just a smoke
It's
screen.
just a small screen to
No,
save
no.
somebody's
See,
skin because he knew
see.
fully well what the implications
No, but you
were.
see, that's speculative.
It's not speculative. Okay,
In law,
But
the case
some has-
was before the
Oh, no,
court,
I think-
wasn't it? The case
Yes,
was before
yes,
a court.
yes.
A defense has been proposed
Yes,
here.
yes.
I'm saying effectively, nobody can say Joe Gatti did not go
And
to
they,
court.
went to court
and they
too.
find
No,
that
no,
the
please,
defense
please,
is weak.
Please,
At the
no,
time
who
when it
found
didn't
so?
matter.
Not
When he
the
went to
court.
court, the
No,
guys had
please,
gotten
that's the
judgment.
point I want to make.
You were going to set aside the
Hold on 1 minute. Yeah.
It is not the court of law that found this defense to be weak. No court, because the case was not dealt with.
All right.
And
Okay.
you came in.
Okay.
But my brother, don't laugh.
Let's do this. Gentlemen, let's do this. Let's do this. I'm now coming to Michael Okwei Jr. He's now going to have his take on the issue as we have raised. Your text messages have been coming in and your emails. I'll be reading some of them pretty soon. I've been watching the clock. I think that my guests don't know that that's what I'm doing. I've been watching the clock and I give them very time equally. Yes, Mike.
Thank you very much, Samson. I'd want to start by saying a very good day to your cherished listeners and viewers as well. Let us go straight to the meat of the matter. What is a judgment debt? Judgment has been given for the debt. Anything else is out of court settlement. Now, for Felix to say that we tried to create the scenario that the payment of judgment debts is corruption is not the position. Because I remember in this country that a man called Hodariokai, who was supposedly wronged during the MPP era, was paid judgment debts. No Ghanaian even whispered. A man called Alhaji Yusuf, who was also wronged during the NDC era, was paid judgment debt, not a whisper. So why are people...
But should we have come to that?
I'm coming. No, because what I'm just trying to tell you is that termination of contracts is part of government work.
a reckless termination of
No,
contract.
please don't use the word
Ought to be
reckless. No,
condemned.
that is, you're making a
I'm
judgment.
actually quoting the Supreme Court.
That is why, no.
The Supreme Court
Please go on.
I would love to.
The Supreme Court Please hold on.
Sorry.
You are giving a subjective statement based on a Supreme Court ruling, but it doesn't apply to the cases I'm about to cite.
have not said so.
So I want to make that clear, because you see, you're a lawyer. You might understand the import of what you're saying, but just in case the listeners may be misguided, I wouldn't want them to be misguided as such.
I'm doing
so
very well to take away all the legalese.
So listeners, what we are talking about is Kululu judgment debts. Judgment debts which have not been dealt with properly, either the procedure, the process, or the basis are flawed. This is what we are talking about. Okay. So anybody who says the mere payment of judgment debt is being made to look wrong in itself is not right. It is wrong. Ghanaians are not, excuse me to say, crazy that any judgment debt we complain about. We complain about those with fraudulent tendencies. Now, what are we talking about in this case? We have been told, for example, that there are going to be new gargantuan revelations and so on and so forth. Well, but as for me, I don't want to listen to the words of people alone. I want to see the actions, because they say actions speak louder than words.
He said that sunlight is the
Best
most effective disinfectant.
Yes, so let's disinfect this judgment debt issue and expose it in the sunlight. And let us go straight to the meat of the matter, looking at the Isofotton.
All that what they are hearing.
Yes. Now, Isofotton. Something. Let me go at least for the 10 minutes and you start like how you did it with everybody. After 10 minutes, you start.
Sorry. I don't intend
I see you are getting. I'm the fourth person. No, you're not heckling, but by now you are into the thing.
Go on.
Let us start with the Joe Gate letter and what Mr. Kweku Bakun told us had become redundant. Okay? When he gave an opinion, it doesn't mean that at the end of the day, that is the main reason why we are doing this or doing that. Look at this same government of MPP in 2007. There was a letter which was signed by the chief director for the minister, that's regard to Minister of Finance and Economic Planning. And this is some of the advice he gave the same government, just as Joe Gate had given before the positions were put together and then the issue went to court. It says, first one, from the above information, talking about the legal threat of Isofotton, it is obvious that Isofotton has no case, 2007, against GOG. That's the first one. Then second one, in any case, assuming without admitting that MFA's contract with Isofotton is valid, Article 26 of the contract properly construed indicates that the contract is only enforceable upon fulfillment of all the conditions precedent. And what are the conditions precedent? This is called the Spanish Protocol.
Yeah.
Now, for anybody to come and sit here and read only sections of the Spanish Protocol without reading, for example, Clause 7, which states that agreements on facilities relative to FAD credits shall be signed on behalf of the Republic of Ghana by a Minister of Finance or duly authorized representative, authorized by the Ministry of Finance. And for the agreement on the other side, the contract with the ministry for...
Read that.
Oh, the rest is institutio, something. There's no need for that. So have I left anything?
How did Isofotton
you can
see
see
this
it.
one?
What I'm trying to say is that for you on the part of the government to be saying that Isofotton has a case, when according to the Spanish protocol, okay, this is something that should have been done.
But the Spanish government wrote.
I'm so sorry.
Can I speak? Will you allow them to speak?
Hold on. Mike.
Hold on.
Because when they were speaking, I kept quiet. Can they make notes?
Hold on.
Now let me continue.
All right.
Spanish protocol. Then the question is, so if there was such a Ministry of Finance letter in our archives, why did they come and mischievously only read to us the Joe Gate letter? Because you see, it wasn't only the Joe Gate letter that was circulating at that time. There were other letters also circulating with this kind of advice from who? The chief director. And yet you didn't find it prudent to come and read that letter. But you come and read the letter of Joe Gate, and even according to what Kweku Bakun is telling us, that Isofotton were making their case based on opinion of Joe Gate. Who gave them that letter? Who is the one who released that letter from Attorney General's department to Isofotton.
They went to court in 2008.
Who are
when
the
they were in charge.
saboteurs? No, but this was
Yes.
not asked about in 2008. They talked about this Jogate letter
No, they
had
added
it.
it.
Okay.
They had it. It was added to the affidavit.
Yeah.
I'll show it to you.
in 2008.
Yeah.
2000.
Show me the year.
Yeah.
Who gave them that
2008.
letter?
2008, yeah.
Yeah.
That is a question we need to ask.
2008, they had it.
Now let us move on even
So you're
further.
asking the Jogate
Please,
administration.
please. When you're talking, I kept quiet.
It's okay.
And I
So
wrote
just-
some notes.
just-
so your
just-
time
just
will come.
make down your
As for
turn.
you, your turn is coming
It'll come
as
to you
I'm reading
soon.
the thing. So you relax. Now, as we are going, we have to ask the second question. In 2011, more developments happened. The next development is that this Isofotton case, from the Ministry of Food and Agriculture, there were two issues that we say have to come to mind. Okay?
You're referring to a letter of
Yes.
the 14th of June,
Yes.
2011.
Thank you very much. Where under
from
the
the Ministry of
NDC,
Agriculture.
yes, under NDC, this is how their own officials saw it at that time. It says the matters raised by professional group, which Kweku just mentioned, such that the date of the contract and its non-compliance with procurement law would have been the basis for a defense against the suit. Their own government minister is advising them in 2011 that
This
they
letter
defend
was
it.
written to the Attorney General.
Yes. Then let me go on further. It says, payment of negotiated settlement has commenced. We seem therefore to be stopped by conduct. Whose conduct? The conduct of the people around Martin Hamidou, who without informing him went and started paying the money. NDC conduct. They come and tell us about MPP. MPP have cancelled the contract, and by law, they were allowed to terminate the contract. And yet, you tell us that by your conduct, then look at the suggestion that they give afterwards, which is very scary. The way forward may be to identify those responsible for the abrogation of the contract, that's in MPP, and charge them for willfully causing financial loss to the state. NDC, what kind of people are you? By your own conduct, you go and start doing negotiated settlement before the professional group report has come in to give you the recommendations that we should go to court. Then you say that because of our own conduct, NDC bad, fraudulent conduct, we should go and catch the former ministers and prosecute them. They say you should go and catch the former people. Can you imagine? In Ghana, you NDC, you say it here.
This is government.
Yes. Government of 2011 is NDC government. Yes.
Yeah,
and the NDC government in their period of 2011, they go and perform a certain conduct which stops them from going to court, from helping the people of Ghana to keep their money, from preservation of our coffers. Then after the government of NDC have committed this bad conduct, they say the people that they must go and look for are those responsible for the abrogation of the contract. I mean, can you imagine? And then we'll charge them with willfully causing financial loss. Then you see, those who haven't gone to school that much, or those who may not have the opportunity of seeing this full letter, will go and only read this thing. The way forward may be to identify, and then they'll say, let's take them to court. Then when they go to court, the letters will come out, then all of this will come, and then they will lose the case. Then NDC will start talking about killing a cat, killing a cat, killing a cat. You have lost the case simply because of your conduct. Now, Kweku talked about various things, for example, with a professional group. And because we don't want repetitiveness, I will go to the letter or the meeting after the first February one, the second meeting. And here are the documents. People in attendance included Martin Odro. They included E. Manfo for professional group. They included Stanley Warman for professional group. Now, at this meeting, certain things happened. And it's very important for Ghanaians not to be confused by the NDC always trying to apportion blame. When Mr. Kudjoto Ablakwa comes to tell us that, oh, this Isofotton thing is going to be very interesting, and so on and so forth. This is how interesting it is. Now,
So I promised.
this is what the professional group, okay, when they came, after carefully studying and analyzing the various documents gathered, professional group, they came to the conclusion that the cases were not actionable. Okay, there were too many flaws with the contracts. Listen to this. There was no basis for the issues raised by Isofotton. Then let us even go further. The reasons why they gave this, that is underlisted as some of the issues. And I'll just give you three of the most important ones. One, the contract was supposed to be turnkey. There were problems with the turnkey. 2, they say that there was no, and every basic lawyer, including some of my brothers who are also studying law at the basic level, they know, contract, there was no offer, no acceptance to form the basis of the contract. This is not me talking. Oh. He's laughing. I think he's laughing at something that happened with Bartinodro there. Laugh at Bartinodro because he's a very funny man. Bartinodro is so funny that they will bring together this group and telling them that there's no offer, no acceptance. Then he went on to say, the signatories on the contract were not signatories recommended by the Spanish protocol. As I read to you, that the Minister of Finance must be the one to do it.
How would you respond to criticisms that you are elevating opinions into binding as a judgment?
No. This is where you are going wrong. The opinions
These are
of
opinions.
wait, thank you very much. Opinions that were given to them, that these people were paid for, $500,000. They were paid to give them an opinion. And when they gave them the opinion at this meeting, they further went on to tell them the premise on which the contract was based did not have any legs to stand on. This is what the NDC were told. Bartinodro, we want to know why they went for settlement. Then the representative further informed the meeting that they looked at the matter mainly from commercial point of view and that the agreements do not fall in force with Spanish protocol, making the contract void. You know what that means? The government itself has sat down in a meeting and the conclusion of the professionals, the consultants, that the government went and asked for their services. They are telling them that there is no basis for a contract. And you know what? Ironically, they are settling with them. Settling with Isofotton. And then they come and say it is MPP's fault. How can it be MPP's fault? When you, the people who has asked these people to go and do this, you don't do it. Then we begin to get further revelations.
You have 2 minutes.
We begin to get further revelations that Mr. Martinamidu is telling us that Mr. Kujeto Ablakwa against government protocol. Because you see, one of the things he tells us, please. Even in the case of ordinary ministerial level, when you talked about the AL,
this Martinamidu's letter,
the chief of staff wasted no time in reminding deputy ministers that under the constitution, they could not write or sign letters in their own capacity. They had to do so upon the instructions and authority of the minister. So if Mr. Kujeto was handling this in an official capacity, he should have taken it through his Minister of State.
Did he write it?
He did not do that. No, whoa, please. You know one thing about communication. These days, because of communication, you know text message is also communication. You know BlackBerry Messenger.
Did he send text message?
Well, that is communication. So I'm saying that if he was communicating,
done a conference
no. Let me land because it's a very important point.
Okay.
And I'm happy you have allowed them to interrupt me on a few occasions because it shall be reciprocated. However, what I'm saying is this: if communication was in his personal capacity, then he doesn't need to do that. But if it was an official capacity, he must do that. The question is, was it official capacity? Okujeto said the Isofotton was going to be a very bad story. I'm quoting him. That's the word he used before this thing came out. A very bad story. Well, bad story is the main one. As for that one is the quote. Interesting is my own addition. Now, if it's going to be a bad story, and then it turns out, as he's being teased in some of the newspapers, that he is now the financial engineer of Isofotton by calling senior ministers of state and begging them to pay Isofotton, then it becomes a very serious issue. And that is why I am telling the NDC that this matter has nothing to do with MPP. It is to do with your conduct and the way you have paid this money when you are not authorized to do so.
Magokwe Jr., thank you very much. We'll get a response from Mr. Kujeto Ablakwa shortly because some of them have been directed directly to his person, as it were, or his conduct alleged. Now, I'll get to these text messages. We'll take a quick break and we'll return to this subject. And you will discover that in the threefold manner I have attempted to compartmentalize the discussion, we have been dealing with the first 2. So when we exhaust that, then we'll come to the proposals that being put forward: presidential commission, prosecutions, surcharging of officials who are found to have recklessly caused those debts and all. We'll find out about that. But I've got your text messages here. Manche Bruce, the second, Takoradi Polytechnic, says, for every good reason there is to lie, there is a better reason to tell the truth. It is not surprising to see how swiftly Isofotton is reciprocating the helping hand given them by Okudzeto Ablakwa. The trust of the innocent is the liar's most useful tool. Ghanaians are now more discerning like never. KSIM Asofa, he writes, or she writes, it was extremely disheartening to hear an NDC man question whether it was well-going democratic, considering the judgment debt crisis we find ourselves in. Does anyone out there think the military will be any better? I can guarantee not only will the situation be the same or most likely worse, but these frauds will never be brought to the public attention. So instead of looking for refuge where there is none, we should take the opportunity to improve our broken system. David Techi Desmond writes, if we say we have nothing to do with XTS, then we should expect another judgment debt in the future. NDC came to ask people to send government to court and pay them judgment debts. That's a wild and serious one. Benjamin Bonti writes, even though businessmen and contractors find it difficult to raise capital to undertake projects awarded to them, it seems they don't work in the interest of the state, but rather they are paymasters, leading to some illegalities, breach of contract terms, and termination of contracts, which our dear nation doesn't have to bear any cost. We need pure and true leadership. Kobe writes, Ablakwa is talking about transparency and good governance, but has forgotten that but for Kennedy Japan's revelation, the country would have been in the dark about all these fraudulent payments by government. Has it been established yet that the payments are fraudulent? Now that the cat is out of the bag, he's embarking on a public cleansing spree in the name of good governance. Manche Bruce again, but let me give some other people the opportunity. Clement, right? According to former Energy Minister, Professor Michael Quay, there was no contract between government of Ghana and Isofotton on the Spanish.
Yeah,
on
even
the
that
Spanish
Spanish
facilities phase.
even that is a huge
So on
problem.
what basis are they claiming judgment
Clearly, he
debt?
does not appreciate all the issues.
This one has no name. It says, we now know why Ablakwa is bellowing for payment to Isofotton to the detriment of the nation just because of kickback. Nana Safo writes, I would like to know if Honorable Ablakwa has benefited in any way from the payment of the judgment debts. Emmanuel, our judgment debts as a country date back to PNDC, NDC days. For this, we should, as a matter of importance, depart from politicizing these debts during public discussions on this issue. Our focus should be how to stop these debts from having survival values. I'll just read this email that was sent in, and then I'll go to Samuel Okudzeto Ablakwa. We take the reactions. I will do some brief run around, and then we'll get back to focus on the solution, because I gather from your text messages that that is most important, and I believe so also. But first of all, you know, an unexamined life is not worth living, so we need to examine it. Now, Dr. Vincent Ejapon writes, Ghanaians need to wake up, and all politicians implicated in these issues should be ashamed of themselves for betraying Ghana. The special care ward at the Accra Psychiatric Hospital has over 200 patients, even though there are only 30 beds. Many sleep in open spaces on bare ground. Many Ghanaians, including members of parliament, die because there are no MIR scanners and other equipment at the Kolebu Teaching Hospital. Many are starving in Ghana, and many are dying daily on our roads, etc. And we so recklessly pay huge sums of money to the likes of Woyome for no good reason. We go to the IMF and World Bank for loans only to use to pay judgment debts. Thank you, Ejapon, for your email. This one says, Orakofo in Takrady writes, if Okujeto claims he discloses various judgment debts for public discussion in the spirit of transparency and good governance, why does he go ahead to judge and to point out in his judgment who are guilty? And very finally, Fatao writes, the Deputy Minister of Information is telling Ghanaians that the government is being transparent. He should tell us how the Wyoming money, which the president ordered not to be paid, was paid.
The
Right.
The Yoko report. That's just that.
Okay, thank you very much. Now, your text message is still welcome, 1422-1760. You can send an email, newsfile@myjoyonline.com. Thanks for tuning in. Now, I'll come to you, Sami. Now, you have had a lot thrown at you this week, and now it's also coming up. It certainly can't go away immediately. How do you react to the charges, for example, that Michael Kwe put at you?
Yeah, oh no, I didn't put the charges at him. Commentators say he's a financial engineer, but I didn't.
Yeah, I would come to that in a jiffy because I want to spend some time on that. But if I can just quickly respond to some of the issues that have been raised by my colleagues.
Okay.
First of all, the accusation has been that these disclosures have been selective, that we don't put all the full documentations out. It's important to appreciate that there are some of these documents which are extremely confidential, which are not even tendered in the courts. For example, the professional group report. It was an internal group that was commissioned, and their report remains confidential. As at when its confidentiality period expires and it can be made public, it will be made public. But you do know that journalists, of course, serial experts like Kwekubako have a way of intercepting some of these documents.
I hope this is a compliment.
It is. And it's good.
That's okay. We can.
No, but you know, Jogate's letter is also confidential.
That one is not. This were on the file.
Sorry, move on.
And it is good that interception has taken place. But you know, there's something. There's something.
Confidentiality will be to you is that. So were you aware of the content?
Oh yes, I'm aware. Do you know that this report, the content, as has been read by Michael Kwe Jr. and Mr. Kwekubako, you know it further sinks the MPP? Listen to the portions that Michael Kwe has been reading, that wrong people signed the contract, there was a breach of the Procurement Act. Who are all those who committed this? Breach of Procurement Act, do you know it's criminal? You know that, something, you know, breach of Procurement Act, that they got wrong people to sign the contracts, that there are flaws in the contract. Are these the kind of contracts that you are entering for the people of Ghana? When you are a government, you are supposed to protect the public purse. International agreement, 8 million euro project. And you know that the people can go to court at any point in time. And you are happy coming here to read this, that based on the professional group's report, we could have gone to court on those grounds. And who will have been injured in the process? Who will have been held liable? Of course, MPP officials, MPP government officials. So they still don't do their case any good. It shows the kind of shoddiness that was at play, the kind of, if you like, wanton disregard for the laws, disrespect for the procurement laws, and absolute, if you like, murkiness.
But if indeed we can establish some level of recklessness on the part of those who conducted this deal, why not? Let the law take its course.
Of course. That is why I'm just cautioning Michael Kwe Jr. not to be so gleefully putting these things out, thinking that, yes, so you could have gone to court and challenge Isofotton, which, and even that, the records show that we did. We went to court. You know that earlier we thought that this Isofotton project did not receive parliamentary approval. Indeed, if you look at the main grounds on which the former Attorney General went to court on the 5th of December 2011, we had thought there was no parliamentary approval. We went to court only to find out that on 27 July 2005, there was parliamentary approval. So it was
the protocol.
Yes, yes. Of the protocol.
Thank you.
Of the protocol, yes.
Just be fair to him. He wasn't in court saying the Spanish protocol did not have parliamentary approval. That's not what he was in court doing. He was in court specifying that the contract entered in with Isofotton,
which was signed after the
did
Spanish
not have
protocol.
parliamentary approval.
Yes.
Let's just be
yeah.
Okay.
I mean, I agree with him.
All right, so
I agree,
move on,
but that is it.
Yes.
But you know that there has been subsequent rulings that these contracts take their life from
But there's a
general
grey area
once there are
there.
general agreements. But
There's still a grey area.
There's a Supreme Court decision
Parliament
like
has
that.
been advised to even do something, re-engineering, so
Yeah.
that we can
So it's not
Fantastic.
that you're
Yeah.
going to
So
use to win the case in court. That's the point.
just to be fair. So pages after pages of the professional group report gives you an insight of the sordid state of public administration in Ghana under the MPP administration. And that report does not do them any good at all. That is why, if you look at the Chief of Staff's letter dated March 21, 2006, which was the basis, that is why I put his name out, for thorough analysis of his conduct in this whole matter. He is the kingpin in this whole Isofotton case.
Well, we are
March
yet to hear
21
Kojo Mpiani because we have
Yes, he's been given the opportunity to speak. I mean, he's been speaking on all matters. This one, he remains.
He's
Well,
not in town.
March 21, 2006. Listen to what the Chief of Staff says. We wish to inform you that the following projects as well as amount earmarked for the project have been approved for your ministry. The Spanish company to execute the project has also been indicated against the project, and he mentions it, Elecno. Is this what the procurement law says? Who approved for your ministry? Jesus Christ, what was going on in this country? You remember Craig Murray, when he wrote this article against the former government, saying that there was a lot of corruption and all of that. What did Kojo Mpiani say in reaction? Very revealing statement. That Greg Murray had come to him, he had been dismissed as ambassador or high commissioner. He was a hungry man. He said his wife had divorced him, so he did him a favor by giving him a contract. So he called the energy minister and a contract was given to him. You remember that story? It was wonderfully put out there. When there is a procurement law about how you bid, how you tender, how selection is to be done. They said another accusation against me is that only the Jogati letter was put out. It's not true. We put out this letter by the Agric minister at the time, signed by Honorable Clement Iledi. Says, I am directed by the Honorable Minister for Food and Agriculture to draw your attention to the fact that the company recommended for the execution of the project in the ministry is unknown to the ministry. And the ministry has never dealt with that company and therefore cannot guarantee that the said company is in position to execute the project. This is in reaction to the Kojo Mpiani letter, the directive that this has been approved for your ministry. Go ahead and do business with them. It is having regard to all that has transpired that the Honorable Minister for Food and Agriculture will want to draw your attention to the fact that a change of company at this stage could open up the ministry and indeed the government to legal action, especially by Isofotton. Unquote. Signed Honorable Clement Iledi. So what was going on? And we are happy about these things, that you are entering into contracts with implications, financial implications for Ghana. And this is how you go about entering this contract. Somebody sits at the presidency and writes a letter that this has been approved for your company, for your ministry. Go ahead. No regard to the procurement law. Is it any wonder, Samson, that in the calf cocoa case, this is what the High Court said. Quote, it is sad to say the least that public officials who are entrusted with the public good and who are expected to act in utmost good faith will so create a situation which will result in creating financial loss situations in the country.
What do you mean?
And this was a financial loss of a whopping $1,750,000. Then in Africa Automobile and Tema Oil Refinery, listen to what the Supreme Court says. In the view of the court, the time had indeed come for state officials to be surcharged with such colossal losses if it could be established, as it had in the instant case, that the losses had been occasioned by their recklessness.
Okay.
Quoting Supreme Court.
Yes, that's.
It says again, this on page 925, the same judgment, that can the defendant be permitted to benefit from this gross display of naked show of power and negligence where there are contractual terms to be complied with? We do not think so.
This is the criticism of the alleged actions of the tall boss at the time, Dr. KK Sapon.
Yeah.
Now, but you're aware also that there's a fresh action seeking to impugn this particular judgment that Africa Automobile
but to the extent that has just
as we speak, this is what is
the judgment
subsisting.
as we speak.
But can we move briefly because you have
so let me come to the accusations against my person.
You have some 3 minutes to deal with that.
Yeah.
Yes.
Yeah, well, we haven't finished talking on this.
When the questions about who will come, you have some 3 minutes to deal with that. Yes.
You see, well, first of all, something I must make the point that when I set about on this sunlight campaign, I did not think that I would not become the object of attack. I knew very much that I would be attacked.
The suggestion is that you miscalculated.
No, not at all. Indeed, I'm enjoying the attacks. That is why I'm back on Monday. You see, because all this judgment day thing, there are all kinds of interests. One, there are unscrupulous business people who hearing about judgment want to go and cash in. The joke now around town is that, hey, Jelly, can I find a contract which has been abrogated and see how quickly I can get it? So this kind of full disclosures won't benefit such unscrupulous business people. Then there are also those who wanted President Mills's administration to be unfairly tagged as judgment-dead corruption administration.
The substantive question is that how did you come in?
And such people wouldn't want that. And they belong to everywhere in the political divide, all sides of the political divide. You understand? Woyome is controversial, it went to court. You understand? But it is not fair. I've heard people. There was a time the opposition leader was asked, how do you intend to fund your free education? He said, I won't pay judgment. I'll use the judgment that to fund my free education.
Ablakwa,
so all kinds of insinuations, innuendos. You know, so there are people who, once this whole campaign, this crusade, is collapsing the sinister motives, agenda, the one-change demonstrations from London to Spain to Takoradi, you know, once this is putting the matters in proper perspective, and people are now saying, oh, okay, so it is disrespectful procurement laws, it is misconduct of public. I knew that I would become the subject of attack.
Okay.
So the allegation, look, I hold in my hands here the petition that was presented by Owusu Yeboah Nyampo and Associates.
Why did they bring that petition to you?
You see, this is a petition which was not addressed to me. It was addressed to the Attorney General.
Why?
It was addressed to the Attorney General, Honorable Martin Amidu at the time, dated April 29, 2011.
And copied you, as you
They said, no, it was copied. I was not even copied. That is why I don't know why I even fell in this. My only crime was that I was at the office at the time they came. But they went to my minister's office, he wasn't there, and then they asked who is around, which are the deputies. I was around, they came to me. Copied to the Chief of Staff, the Deputy Attorney General. And I'm happy that I called the Chief of Staff and other ministers about this matter.
Hey.
I would have to inform them. I would have today been under suspicion, you understand? But all of them are laughing this matter off, this allegation. What was the call? Honorable Martin Amidu, there are some people here say they are from Isofotton, they have petitioned government and they have not got any response several weeks. I just wanted to find out if it is true.
The question is that why would they come to your ministry?
Ministry of Information exists to disseminate information and also take feedback for government. We are the doors, the window of government, if you like. Everybody comes there to make enquiries. Everybody on a daily basis. This scholarship, how do we get it? This we're trying to locate NYP office. How do we find it? On a daily basis. You just come around, spend 1 hour with us.
Trying to locate
on a daily
General,
basis.
how do we find it?
You know,
They didn't know where to find it.
And the call was not that payment should be made. You remember in the Woyome case, you remember that I was one of the government officials who were vilified, attacked. There's this group. I have here a statement which they issued.
Okay.
The NDC, Volta Region, Youth for Action. You know they chastised me for refusing to defend the government and defend the Woyome case. If 51 million was at stake, I stayed away. I was being accused for not joining in that enterprise, and then $1.3 million.
Right.
It is a very, very unfortunate and cowardly attempt to attack my person.
I'll come to Kweku, but before I do so, I have a message, and it is from the former Attorney General, Martin Amidu. I'll read that to you now. This
why are you
some
so
communication
excited?
he has had with us, and reduce into this. He says that the Supreme Court in the Balkan Energy case, giving on the 16th, sometime in 2012, said, in the interim, a certificate by the Attorney General that an international business transaction to which the government is a party is, major or not, should be accorded great weight by the court, although it cannot be conclusive. The Supreme Court went ahead in spite of a similar letter in the Balkan case by Joe Gatti to decide that in spite of his letter, that the Balkan Agreement did not need parliamentary approval. On the facts before the Supreme Court, the Balkan Energy Power Purchase Agreement was an international business transaction and void for not having been laid and approved by Parliament. Kumbo was in court when the judgment was given, and the government is deemed to have known this when Okujeto put out the statement this week. Okay, so this is from Martin Amidu. Thank you very much.
Yeah, my brother. This report, which my brother Sami thinks indicts the NPP.
In many ways.
Yes, in many ways. And if so, one would have expected a responsible government to have implemented its results. It says it's confidential. I'm not sure about that. There's no indication here. But of course, it was paid for by the like taxpayers' money. Almost $500,000.
And to be fair, it was not for only Isofotton, a number of cases. When
Oh, I
you put
know.
that out, it creates pressure as just one case, $400,000.
No. For this particular work, they were paid $130,000 for each copy they submitted, and it was about 4 copies. I know about that group and the other jobs they are doing.
Yeah.
I know.
Other monies they are chopping.
Well, I will put it that
Let's
way.
go on to that one.
No, it's
Why
not
are you
fair.
always quick?
Okay, please.
Yes,
Can you hold it? Can you hold it? Hold on.
No,
Let's
Mike,
hear Kuku.
it's not fair.
Let's hear Kuku. Yes.
They are a group of professionals. What we can
men
do
of
next
integrity.
time is to find out whether
Because they don't use their reports. So why are they commissioning them?
Okay.
If we use it, you'll have been in jail.
there are
Mike,
issues.
I'm not going to allow anybody to heckle you. So let's go on.
There are legitimate issues to raise, but it's not in this forum. How were their services procured in terms of law and things? But that's not what I'm doing today. See, I will read just some portions. Page 27. They say, like the previous transaction, whilst Intercatema Indema was sole sourced under Act 663 and contract duly signed by the Minister for Finance and Economic Planning, the Isofotton SA was sole sourced but not under Act 663. On the other hand, the contract was signed by the Minister for Food and Agriculture and not the Minister for Finance and Economic Planning as required by the protocol. With these shortcomings, the contracts of Isofotton SA could not have qualified to be financed under the second Spanish accord, protocol. Second one, I'll do it and make my comments. The second one, they make a point about a commercial contract, that's page 29, is considered complete when issues to be considered are disclosed and or defined in full, eliminating any doubt, any element of doubt, uncertainties, and ambiguities. Then they give a long list of things that ought to have been done, but they say the Isofotton SA contract failed to provide. Then they make this conclusive point here. In the absence of detailed facts, the Isofotton contracts, which though had been signed, cannot be described as a document that can be considered as an appropriate commercial contract. Isofotton contract, they make them say that such significant alteration. They were talking of signatures and things that had been changed, alteration of date of contract and things. And then they make this point. Available, such significant alteration without an endorsement by the principal signatories of the agreement defaces the contract and thus constitutes enough grounds for its rejection. Now, Sami is
Opinion.
focusing, oh, it's an opinion we have paid 100,000
Yeah,
for.
I just want to say,
No,
it's
no,
not a judgment
but everybody
of the
knows
courts.
I'm reading.
Yeah.
Oh, fantastic.
Yeah.
You just said it's not a judgment of a court. And that's exactly the point I made about Jogati's letter.
Your settlement was not a
Yeah.
judgment.
It's not a judgment of a court.
Yeah.
And I have not hidden the fact that I'm reading
Yeah.
from
Judgment.
Yeah.
It's a settlement of the court.
La ilaha illallah.
Sorry. I didn't intend to.
Judgment of the court.
Yeah.
Let's go.
Yeah.
It's adopted.
Exactly. So,
I didn't, have I,
Which
have
we-
I
no,
said?
They were
That's
just
my
trying
two
to make an
seconds.
explanation.
Oh,
Let's
sorry.
stop here and allow Kuku to
We
go.
inherited
Please,
a
Kuku.
consent
Kuku,
judgment.
move on. No more interruptions. Let's go.
No, what you said is not correct.
that
That you inherited consent judgment
Yes.
on Isofotton.
Yeah.
No,
Never.
it was entered in by this administration.
You went to
Yes,
negotiate.
yes. Please. That's why you went, filed the application to set the default size aside. In, I have the documents here, I can prove it.
No.
But let me deal with
You
my
don't
issue. I
have the
don't want to be
proper
like,
sequence. You don't have the proper
I
sequence.
will prove my case.
You're mixing
go ahead,
default
go
and
ahead.
consent judgment. That's
We'll
what
get
you're
that
doing.
cleared. Kuku, go.
Yeah,
We'll
I'm
get that
talking a
cleared.
default judgment.
Okay, you're not talking about.
Are you aware of the
now-
default
No, I'm not
judgment?
talking before.
Are you
I
aware
thought
the
you said
default judgment?
consent judgment is
Okay.
different.
No,
different
Sorry, he
from-
meant default
I
judgment.
meant default,
Okay,
default
so that's why
judgment.
you were wrong.
That's
Let's
right.
go on. Yeah.
No, that was
but
just
the
one of
process for
those
the
things.
consent was begun by
You are not
Yeah.
familiar with the process.
Okay.
You let Kuku continue.
Please,
Hold on.
please.
Yeah.
So, my brother, I was reading that. So these are things from this report, commissioned by this government at the expense of the taxpayer to the tune of $500,000. Now,
I'm contesting the figure.
okay, no problem.
I'll-
nearly
we'll put the
500,000.
right figure out.
Okay.
But, my brother, they did not just ignore this report, but they preempted it. You commissioned this job in August. Whilst this job was being done, you went for out-of-court settlement with the plaintiff. September 29th, you filed the consent judgment in court of law. This thing is then brought to you in November. Look at the sequence and ask yourself whether this reflects good faith, integrity of the matter. That's my argument.
Do you know of the garnishes?
Oh, you see? So I am saying you preempted this, and yet you knew you had commissioned it, and you were paying $500,000
Do you know
nearly.
why they had to do that?
Sami, please note them. Note them.
Okay,
See.
I'll know them.
Our listeners and our viewers are our judges on this matter. That the government commissions such an important job, pays $500,000 or nearly, to be precise, for it, 4 copies.
More than.
And before it received this report, it entered into settlement negotiations and filed a consent judgment in court. I'm saying that these people had the benefit of hindsight. According to Sami, the MPP guys messed up terribly.
According to documentation.
Yeah, I mean, based on the documentation, according to you.
Oh,
Now, you had the benefit of hindsight. Before you, your own reports had come to you. And yet you had gone ahead and effected payment. Indeed, as I indicated, as we speak, that case filed by Martin is pending. Who is more irresponsible here? Look, financial loss, we look for the willfulness.
absolutely.
yeah, willfulness. Like Kojo Mpiani's like.
You think so? Fair deal. You determine that, like the Minister of Agriculture letter was predicting that we can deal with them. But if in spite of all this info given to you by your own committee, and the fact that you had said you had trust and faith in that group, so you gave them this job to do, and you knew you were going to pay that much money to them, but you did not wait for their report, but proceeded to negotiate a deal and pay. That's not willful. That's patriotic. That's very responsible. And we need to clap for them. That's what we are being told. So please, that is the point I was making about this. Now, Sami makes points. And you see, I think that's one thing we should all agree, that we can get itemized cases across our historical experience and political divide that will point to a lot of things that may have happened. But each time he makes the point, he uses only some particular ones. You see, he was mentioning the Africa Automobile and TOR. The same Supreme Court on Africa Automobile and the AG, the case involving Ministry of Information, found out that AAL, in collusion with some people in the state sector, were about to defraud the state of Ghana.
But I've talked about unscrupulous business.
No, but I'm only, what it is, no, I didn't say. His example is okay. I'm only adding, I'm saying that I'm adding to it.
In that matter, Kukubak, in that matter, the claim by AAL was for 14 million Ghana cedis. And somehow the state was lucky and was going to get just, AAL was going to be awarded only 1,500, a little above 1,500 Ghana cedis. And yet, you had the state attorney run to the judge and suggest that we are ready to submit to a judgment in the sum of 14 million.
That's right.
So it is that judge, Justice Gertrude Tokonu in the commercial court, who said this will not pass. And then the high courts upheld same, and then it went.
Fantastic.
Like
So
that.
I was bringing, you see, we should look at it in a broader manner.
Very great judge.
That out there are companies or people who come to tell us that there's liability. And in times, the documentation they bring to support the so-called liability, including the interest calculations. And in this case, you know it was so. The interest calculations, all are such that we have to be careful and not say that, oh, because look, the interest is building, let's run. When you properly scrutinize, you may find a problem on the side of those who are chasing us for liabilities, and not only public officials who may have been irresponsible or reckless in their conduct.
Okay. Thank you very much, Abdul Malik Kwekubako Jr. I'm going to give Felix 5 minutes, and then he would also say,
no, but have you finished with this topic?
We are coming on the substantive last part of it about the solutions. Okay. Because all of you needed to do a bit of some reaction here and there. Now, I need to announce to you that Newsfile is brought to you by the kind of sponsorship of MTN. MTN, everywhere you go, and the Bank of Africa. Now, imagine if uploading your Facebook pictures took a second and your favorite web pages loaded instantly. Non-stop imaging, and get yourself an MTN pocket internet modem for only 49 Ghana cedis with 5.5 GB data free. Get more value from your MTN modem. It's a super saver deal only from MTN. Surf more, chat more, and download more at supersonic speeds and explore your world of possibilities. MTN, everywhere you go. And this is Newsfile. I've got some messages here, but before I do so, I'd like to get to Felix. 5 minutes, Felix.
All right, thank you very much. Again, you see, Kweku's consistent dwelling on this committee's report brings us back to the point that I made earlier on. At the time that Kojompini wrote the letter to terminate Isofotton's contract, were those the reasons cited for it? Again, this group's report only channels the letter that my Kwekwe read to you, that persons at the Ministry of Finance wrote to the Attorney General informing him that perhaps due to breaches of the Procurement Act, the contract may not be valid. This letter was available to Joe Gatti. Indeed, it was the Ministry of Finance that took this matter to Joe Gatti for his advice. Joe Gatti's letter of June 4th, 2008 was addressed to the Ministry of Finance, or the Minister of Finance. And yet, Joe Gatti did not think that this was going to be enough grounds to defend government against the suit brought by Isofotton. That's why he didn't go to court. Instructively enough, this whole argument is, please, Joe Gatti, did he go to court? No.
He went to court.
But
he applied to set it aside.
Please, let me land. After they had gone,
But you come in, hold it.
After the guys,
What is a lie?
Oh, what is a lie? After the guys had gotten judgment, Joe Gatti knew this even before the guys went to court. This letter was written in 2007. You yourself read it. Joe Gatti's letter came in 2008, almost 1 year after this letter had been sent to him. He was fully aware of the facts. But the point I want to make is that the Spanish protocol does not say that it is only the Minister of Finance who can sign on behalf of the government of Ghana. It says that the Minister of Finance or his duly authorized representative. The Ministry of Agri makes it clear in their letter of 4th April 2006 that when they met the Minister of Finance, he authorized them to identify appropriate companies and enter into contracts with them. So the Spanish protocol had not been breached. In any event, the Ministry of Agriculture made it clear the processes that had been gone through to select Isofotton and the fact that Isofotton had started executing the contract. So we could not go to court on this basis, and that is why I suspect Yogate ignored it when they brought the matter to him. But you see, if you go to the energy side of this whole matter, it becomes murkier. You had a situation where Isofotton had a long-standing commercial agreement with the Ministry of Energy. Indeed, in 2001, Honorable Kandapa signed on behalf of the government of Ghana. So they were expecting that under the second phase of the project, they will get the contract to execute. Then Professor Michael Quay comes into office. He informs them that indeed, because of the passage of the Procurement Act, he is compelled to restart the process and make sure that there's a competitive tender process. He then invites 5 companies to bid for the project. And then bids were supposed to be opened on the 6th of February 2005. Now, Isofotton bids, they are invited for the bids to be opened. When Isofotton got there, they were told that the, tender committee could not raise a quorum, and so they will be written to later. Later, they were written to and informed that as of the time that the bids should have been opened, on the 6th of April 2005, they were the only company that had put in a bid. And yet, without recourse to due process, another company, Elecno, was selected, who had not gone through any procurement process. They were not part of the process to select companies for this job. So even on the procurement arguments, the MPP cannot extricate itself from blame. If you accuse Isofotton of violating aspects of our Procurement Act, how then do you select a company that doesn't go through procurement processes at all?
They did so
to execute. What is so
by your own report here.
No, listen.
It's allowed by the Procurement Board.
Isofotton had been sole sourced.
I'm only stating the facts.
Isofotton had been sole sourced in 2001 to execute this contract. Professor Michael Quay informs them that because of the Procurement Act, they need to go through competitive tender processes. They go through the process. They are the only company that submits a bid. When the bids are to be opened, they are told that because of the lack of a quorum, the bids cannot be opened, and that they will be waiting to. Later, a company is then selected ahead of Isofotton. That was not part of the competitive process that Professor Michael Quay said was the basis for the selection. So how can you engage in such double standards? The reason why Yogate didn't go to court, and I submit that it was because he was aware of these matters.
So
reasoning
for you, his subsequent, steps
even
to
that
go
is
to
flawed.
court does not matter.
It is flawed. You see, it is flawed because the reasoning, the arguments he's raising, is defeated clearly by the letter that the Spanish government sent when they said that indeed they were not the ones to give approval for companies to be selected.
Thank you very much, Felix.
No, Felix, the defense was not talking of just selection. It was talking of approvals that were
the Spanish
needed by
government
both
does not
governments.
require any approval. They won't give any approval.
Gentlemen, we need to move on.
No, but the protocol had been
Sorry.
So
Not for
sorry.
the things that are in the protocol.
Sorry.
Who told you that?
The protocol has been
read it well.
The protocol has been
Kwesi
approved.
Bediako in the United States of America, right? So Kudeta Ablakwa has no credibility after being accused of asking the former AG to pay Isofotton unwarranted money. The NDC government has lost focus, and Ghanaians should vote them out in December. Ura from the USA, right? I find it difficult to understand the NDC. Are they the only government who is paying judgment debt since independence? Besso, right? In fact, I was ashamed to see the Public Accounts Committee chair watch Mrs. Betty Moldidrisu in great awe. In spite of his strong critique to this woman, he had to take refuge under the bogus powers of the park to dodge apologizing to the woman whom he blatantly downgraded. Ata Imoro in Walensee writes, payment of judgment debts has been with us since Nkrumah's time. The concern of many, however, is that why has it become an issue now? I suppose because of their gargantuan nature and the dubious ways by which such judgments are secured. James Opong Jr. in London writes, my major concern lies with the manner in which the judgment debt has been politicized to the extent the government officials are defending the beneficiaries. Also, why is the NDC government so interested in these judgment debts? It has been said that dying animals struggle to death. I think that is a revelation we are seeing now. This one has no name. It says the recent media upsurge about judgment debt discussion is as a result of wanton disregard to lay down basic procedure in our public administration practice by some politicians and public office holders. It is incumbent upon government to, as a matter of urgency, to fish out these unscrupulous and faceless individuals involved to face the full-fledged of the law. Fatao says, I agree totally with the current AG that more judgment debts are in the pipeline. It shows how loose the NDC government is. Ni Aite in Accra writes, I would like to know from government why they refused to disclose to Ghanaians before deciding to go for settlement, but are now disclosing after they have recklessly handed out monies to foreigners, and they are also defending these foreigners while we continue to pay them our taxes. Joe Mensah writes, can Ablakwa tell Ghanaians how much the abrogation of the SES contract is going to cost Ghanaians? I see. Benjamin Pore in Nongua writes, in 2009, the NDC made Ghanaians to understand that Ghana was at the intensive care unit financially, only for us to realize that Ghana has millions of dollars to pay judgment debt. Meanwhile, we are not able to provide jobs for Ghanaians because we are poor. Why are we able to rush to negotiate to pay judgment debt when the case is even in court? Opele Inwa writes, NPP will forever stay in opposition until President Mills, okay, you wanted to say maybe divest this country of corruption and all sorts of judgment debt. Sami in Koforidua writes, when is the president going to confirm Okudzeto Ablakwa as Deputy Information Minister with additional responsibility as Minister in charge of judgment debt? Interesting one there. AU Farouk in Tamale writes, MPP should be blamed for the so-called judgment debt. Even when President Mills was to be sworn in, MPP were still paying judgment debts to their party cronies. Titus in Tepa writes, the UP squads are behaving as if the NDC created the judgment debt they are now paying. The last one here says, is this from who? Our man in Yeji. God bless Martin Amidu for saying it all. Amen. No contract, but forgery to loot the country. NDC won't care if the nation burns, provided it will give them the opportunity to fiddle. What? Let the NDC government know that Ghanaians will not be voting based on judgment debt. Now, Michael Okwe, 5 minutes for some reaction. And I discovered that you took a shot at Barton Odro and Martin Amidu's, recent epistle about him, that he sought to do things to usurp his authority and all. Now, Martin Amidu is suspecting collusion, just like some of the courts appear to have.
Okay, let me quickly start by dealing with the issue of the professional group, where when I mentioned the chopping of money, it may look as if the professional group were the ones who were to blame. That's not the impression at all. What I meant was, after them being paid such expensive amounts of money, the advice should not be ignored. It is not small advice. It should have been taken into consideration before any decision was made.
Irrespective
so, as a professional group, yes. So, professional group, I respect your opinion, and whatever money you are paid for your consultancy, you must deserve it. So that is not the issue. But I would just want to say, but I want to just make this clear that when I go and appoint such an expensive group, knowledgeable group, when expensive is not only the money, the brain. President Kufuor says, as for Ghana, sometimes we want to know the cost of everything without the value of the thing. Sometimes some things are much more valuable than the cost at that time. You understand what I'm saying? So if we go and ask them to come and give us this valuable information, and we preempt it by taking certain actions, which end up being contrary to the view of such valued professionals, then it is very worrying, and we need to query the situation. Also, in the MPP, we have hierarchy. We don't have a situation where deputy ministers, whether it's as alleged Barton Odro or also as alleged Okudzeto Ablakwa, can usurp any bureau and do anything anyhow.
So let me remove. Okay, let me remove Okudzeto from it.
Sorry, I apologize. Okay, so let me go to. I apologize to Mr. Okudzeto. He did not usurp. I'll come to him later. But Mr. Barton Odro is alleged to have usurped the powers of Martin Amidu. He was the boss. He says my deputy did things without consulting me. You are not there, so you wait.
No, but
now,
it's documented.
Yes, it's documented.
Quite a lot of the negotiation settlement was headed by the deputy.
When you were a minister of state, whether minister of energy or minister of agric, and the presidential office via the chief of staff comes and give you a directive that this contract that has been awarded by our ministry, we are changing it because of so and so. Some of them include, you see, the Chief of Staff's office, Presidential Office, they deal with Ministry of Foreign Affairs. They deal with embassies. They deal with Spanish government. They deal with entities that you, the Minister of State, you don't deal with. So when you are given a directive, you follow it. And the professional group's advice has also shown that the directive given by Kodjon Pini was right.
What directive is not true?
And
There's
that's
no
no breach of contract.
It's not true.
Professional group didn't say that.
Professional group said that.
It's not true.
Wait. Please. Payment of the negotiated settlement has commenced. Okay? We seem to therefore be stopped by Estopel.
Is it
in the circumstances?
No,
if you want the professional group one, let me just
rationalize it after this.
This is the
what
letter.
you're reading is not from the professional group.
What I was reading was a letter that was warning them that in light of the professional group's advice, I wanted to give you what we call conclusive analysis. But if you want
this from the chief minister of the Ministry of
looks
Agriculture.
more,
in 2007,
it looks more bizarre.
it is a fact. So let me. No, this is 2011.
Yes.
Under NDC. They gave them what we call the conclusive. This 14 June. This is in April. The meeting of the group was in April. So this letter is encompassing the meeting of April. But since you want me to go step by step, I'll go step by step for you. I just thought you didn't have time.
Well, actually, you have like 2
So if you don't have time, can I go for the June that came after the April? You see, this is the problem. And this 2011. I will not sit down and not give the right chronology of affairs, unlike some people here. So let us go with the matter. I'm telling you that it's a stop by our conduct. In the circumstances, I doubt if we can successfully set aside the judgment and defend the suit. That means, but for the conduct of the NDC, they would have attempted to set aside the judgment and defend the suit. This is the problem here. Let us look at all of this in the quick behavior of the NDC. They talk about judgment debts and contract termination as if it's a crime. If you look at the Times, this same Monday, July 9th, a contract was terminated by the Ministry of Roads and Highways against Lomenf Construction and given to Legna. Okay? Then NPP comes to power. Oh, because NDC terminated STX or they terminated Lomenf, we are justified in paying wrong money. We are justified in doing kanana. We are justified in going into a room and go and settle when the case is in court. We are justified in trying to settle 1.5 billion kind of settlement without telling the Attorney General. We are justified in all these processes and procedure. This is what the NDC doesn't seem to understand. We are not complaining about judgment debts for the sake of it. We are complaining about your behavior during judgment debts. And look at what Mr. Okujeto Ablakwa said. The people came to him because maybe they were trying to locate Mr. Soso and so they could not find him.
That's not what I said.
So, that's what you said.
That they had sent government a petition, they hadn't got a response.
You said people come to the Ministry of Information because they are trying to locate Mr. Asom, you have written it down here, and I put it in quotation.
Talking about the ministry being a gateway to government.
So the gateway, the gateway.
To government.
The gateway, Okujeto Ablakwa, the gateway. Okay.
Please.
No, he's a gateway. Let's go there. It's important.
This is not fair.
Let me land, because they heckled me. Let me land.
30 seconds.
We are trying to locate so and so. Where do we find him? Then they come to him. So when they come to ask Mr. Okujeto Ablakwa,
the ministry, not
yes,
me.
the ministry. So if you are trying to locate the ministry of the Attorney General's
this
office.
one, in this case, there was a petition. Why are you doing this?
So if there's a petition, you file the petition.
But the Attorney General already had a petition.
They already had it. They were-
What's the
Okay. No. It's serious because Okujeto is even telling us that he didn't only call the Attorney General because that's what I was going to go to. He also even called Chief of Staff. He's lobbying.
What
Why are you calling all this?
So when your dad was nobody called him to find out the state of
I don't know.
Mike, I think let's go this way.
This is short.
Let's go this way. This is a quotation that Mr. Ablakwa has already referred to in the 2011 Supreme Court ruling on the Tema Oil Refinery versus Africa Automobile Limited. The judgment was delivered by Justice Doche. Now, this is a portion of it. This is page 937, and it says that, on the contrary, I'd like to read from here. It says, on the whole, it is surprising. It is surprising that learned counsel for the defendant sought to question the propriety of the management style of the plaintiff company. Plaintiff company meaning AAL. And then the court is saying that, on the contrary, it is the defendant company, that is AAL, and its top management, exemplified in the first and second witnesses, which included the MD, which calls for swift condemnation.
Tort, right?
Indeed,
Tort,
yes. Indeed, if businesses are to be conducted as was done by the defendant company, that is Tor in this case, then all businesses will collapse. All businesses will collapse and run into serious debt. We believe the time has indeed come for state officials to be surcharged with such colossal losses if it can be established, as it has in this case, that the losses were occasioned by their recklessness.
Very good.
Question is, the very last point that we need to deal with, there are proposals as to how we can stop this hemorrhaging of the state coffers, as it were. Commission of inquiry, prosecutions, surcharging of the people that are involved, engaging external solicitors, and you should know where that argument is also coming from. Because we also have the AAL versus this particular case, and we discover that because external solicitors were used
By whom? The state.
were used by Tor,
Question is very long. I'm confused.
Tor's award, initial award at the court of the High Court of over 900,000 euros was reduced by nearly 500,000 euros. They went to Court of Appeal, they went to Supreme Court, attempted a review which was rejected. As we speak, they are back in court seeking to get every dime, as it were. They think that AAL does not deserve a penny. The last reference is also the AAL versus the AG, in which a state attorney is reported by the judge to have come to her to suggest that, look, we are ready to take the debt of 14 million Ghana cedis instead of the 1,500 that you want to give them. Commission of inquiry, prosecutions, surcharging, all of this mix. Where do we go?
I get the question. Very first and foremost, it is very difficult for me to comment on the AAL versus Tor because that was just introduced on this program. And when you sent us the things to prepare for, you didn't add it.
No,
I'm coming.
Yeah.
So I won't want to take selective paragraphs.
Not at all.
And talk about. So I will go and look at it in detail and at the appropriate time bring detailed, appropriate response for the benefit of Ghana.
We are looking for solutions.
However, yes. So let us move on into the causation issue.
Causation.
Yeah, I mean, talking about those. Yes,
there are proposals for commissions,
So,
for
solution.
prosecutions, for whatever, surcharging of
this
officials.
one is very good in terms of looking at the thing as source. That is a problem that has existed in the days of NDC. That is even from PNDC time, NDC 1, MPP, and now NDC 2. There has been
NDC
always problems.
3,
Well, NDC 3 because 2 and we are looking at issues where the second second period. Now, what we are talking about is this. There is that problem where state officials, do you know at the moment there's even a proposal that if you are driving a state car and you use the car to hit somebody, the state should not pay the insurance for that person. You, the driver, if you are reckless, you should pay. All of those things are there.
What happened to vicarious
Yes,
liability?
that's a vicarious liability should no more operate. And I've even heard people like Tony Edu, who gave a brilliant analysis a few days ago on this issue of vicarious liability. Yeah. And that is true. So let us look at the issue of vicarious liability as an entity. But let us also look at the issue of payments. That's the second umbrella. These payments are being done in what way? Are being done in a way where ICQ was, for example, saying still less.
You see?
Still less. Because, you see, when you are now charged with the responsibility of paying because, let's even assume, there's a judgment by the court, and you go and use a bad manner to pay that money, are you not even worse? This is the issue, because somebody did a contract issue, and there's a problem. Maybe he didn't know any better. We are going to court. The court said we should pay. Or in some cases even, the court has not even finished looking at the matter. Then you go and take it, go and hide, you don't show it to Attorney General, then you go and pay. The question now is that, why is it that under this government, there seems to be so much interference with judgment debt? Is it for personal gain? Because personal gain can be, for example, even a person is a relative. Okay. Or are we looking at financial gain? Where, for example, certain ministers are being touted to say, oh, why is it that you are going around doing financial engineering? Trying to engineer the process in a way that the government of Ghana seems to be the loser. Look, as I gave you with the Lomenf case, if the MPP government comes into power and we start saying that any government that the NDC has terminated, therefore, we have to pay judgment debt. No, we have to defend government of Ghana. But the NDC people, they seem to treat the situation like there's government of NPP and there's government of NDC. And as for NDC, when they came to power, anything that was done in the NPP time is wrong. So therefore, we are going to side with the other party and defend the other party against NPP government. And in effect, what they are doing is they are cutting their own nose to spite their own faces. And this is where Ghanaians are complaining that, did you come to power to continue government business or only to look at NDC interests, which seems to be that, oh, let us say NPP committed an offense. Let us cut a deal, big deal for that matter, and chop the money. Wrong. Look, Rockshell. Was this not started?
I was hoping that the direction would be that we have done sufficient diagnosis of the
it is
problems.
true. It is true. But let me give you this. Rockshell, the money that they got.
By looking at the solutions.
The money that Rockshell got, where was the problem from? It was from PNDC. Does that mean MPP would have been justified to go and give them 35 million? MPP negotiated about 12 million with them. Despite the fact we accept. This is the problem. We accept. Then some was paid. There was a balance. NDC paid the balance. Then you rather go and pay 35 million. Then when they ask you, why do you pay 35 million? You say, because MPP did not pay all of it.
If you say that, then the same argument will be used against you.
That's why I'm saying that we should stop that.
You ought to have paid.
And we should take responsibility for our actions when we are in government, that if a previous government has committed a mistake and you are now the new government, it is continuity. Our constitution tells us that as far as possible, we must continue government projects.
Directive principles of state policy.
So in that same way, this constitution is telling the Mills Mahama government that they should continue to pay judgment debts where we are found liable. But where we are not liable, we shouldn't pay. Thank you. It is genuine. Debts. They should pay. But if we are not liable, they shouldn't pay. This is the argument. I don't understand why NDC are trying to make this thing judgment debt.
Okay. Let's hold it there. We take a quick break. When we return, I will get to the other panelists on the show, and we'll continue to look for solutions to the judgment debt. Now we have some time to continue looking for the solutions, but I have some interventions coming through. Martin Amidu and also an administrator at the Agric Ministry. I'll bring that to you in the next 30 seconds. 30 seconds.
Thank you very much. I mean, I understood to just
30 seconds.
Stop there, because I know the adverts too are a very important part of the program. But just to say that, NDC, please, we went to Public Accounts Committee. This is not just a hearsay. When we got there, a family, a Suchari family, they've been given 1.5 billion according to your records. Yet the man whose name is there died 6 years ago. 6 years. And the person who inherited him and is now the head of the clan says he has not received such money. When we go and ask, they tell us it's judgment debt. How can you pay judgment debt to a ghost and come and tell Ghanaians that it is a judgment debt? So you see, this is why we must make sure that the payments are right. Then at least we can now look at the problem that occurs before the judgment debt.
The one who is diseased and the judgment debt is paid to. I suppose that when he died, his family or the rightful people would have gone for letters of administration, would have been authorized.
And nothing like that.
So it's a genuine error.
Sure,
yes, that's what the man, he said at the PAC.
So let's move on. Let's hear,
in evidence, in camera.
Let's hear Martin Amidu again, the former Attorney General. He says, Okujeto and myself had a confrontation on Oman FM at which he spoke the truth spontaneously. He's now rationalizing the indisputable fact after he tried to interfere with the case in court by pleading with me to authorize payment and his personal interest in Isofotton by going round washing his shame with changing versions. John Tia said on another radio station yesterday that Okujeto never brought the alleged petition to his notice. The chief of staff is not his minister. So telling him does not excuse him from not bringing the matter even later to John Tia, his minister. Clear proof that he is now telling lies. Ghanaians heard us on radio and will not be deceived by his youthful lies. Ghanaians know I stand by the truth. Martin Amidu sent in that one. And I'll read this one to you. This is from Mr. Seth Domega. He's an administrator and lawyer at the Ministry of Agriculture. In December 2011, Martin Amidu, then AG, went to court on a motion to set aside the default judgment of 2008. He supported his motion with all available arguments raised by the professional group, as well as constitutional issues. This motion was dismissed on the 2nd day of May 2012 with further cost of 6,000 Ghana cedis against the Republic. This was the basis for the pending contempt proceedings against a Bank of Ghana. Is that what I'm supposed to understand it to represent? Thank you very much for all of that.
Yeah, but what's the relevance
I think
of that? I'm not sure.
These
Just
are
to show that
interventions that they are making.
the consistent reference to the special group's report
Okay.
does not in any way invalidate
No,
the
but the
agreement
point
that mentioned.
made
That's
is
all.
that you no. You set up a
Yes,
committee
but
to
subsequently
do work
didn't
for you,
change
and you
anything.
preempt. No,
It
but
did
that's
not-
bad
it did
government.
not undermine
You pay money.
what
No,
the Nigerian
you
made
can't.
that point. In such way that
No,
okay,
you
that's
cannot
a substantive
rationalize it that way.
Gentlemen,
You
the point-
cannot.
Gentlemen,
You
the point you
cannot
have made.
pay.
The point you
Use
have made.
our money.
The point you have
to
you have
pay
made.
for
have
a
made.
document
Because the payment
that
was
you
not
didn't wait for.
have been made.
No, but what the payment
I'll
what are
ask
you
you
talking
to
about?
do
So what are you
You
attacking?
specifically because
That
you are-
government was
What are you talking about?
All right,
Is that how you
gentlemen,
govern the country?
Gentlemen, thank you
Those
very
who
much.
breach
That you set
contracts
up a committee?
Now, I'm coming
What
to
are we
you.
talking about
I'm coming
here?
to you,
They're
Felix.
coming to you.
I'm coming to you, Felix.
All right.
Abdul Malik,
This
please
is
hold
a
on.
top
Please
bar
hold on. Please hold
governance.
on.
Please go.
Now, this show is brought to you in association
about
with
who
MTN, everywhere you go,
They got
and the
it
Bank of Africa. I'm shouting. I don't want to do that. I'll lose my voice.
No,
just go.
Now,
you
Felix.
don't set
Now,
up a
Felix.
committee, pay them $500,000, and
We are
you ignore it,
We are
preempt
asking
the
for
report.
solutions. Abdul
What are we
Malik.
talking about?
Abdul Malik, please hold it.
Why is-
We are asking
why is-
for.
why
we are
is
asking
Bombay
for
so-
solutions.
Come on.
As if it makes a substantive difference to the case.
We are asking for solutions.
shows-
This
it
is
They
how-
can't show anything.
this
Those
is
who
how I
are fault
start
are
my
those who
question.
abrogated the contract.
Gentlemen,
Not this one.
No,
Gentlemen,
it's self-serving.
Go ahead.
What you are saying is
Live
self-serving.
up to my description. You are gentlemen. Live up to it.
sorry.
All right.
I'm sorry.
Okay.
Sometimes it's a jujube.
All right. Thank you very much.
All right.
Okay, so you cease fire there.
all
Now, I'm now going to ask you the solutions that we should be finding. This, you say, is a sunlight crusade. As much as it's important for us to know all that is happening, it is also important to know how we can stop the bleeding.
Yeah.
How do you feel when you discover that in most of the judgment debts that went to court, and it was the Attorney General that was putting up a defense, the judgments were procured by default?
Well, absolutely. That's a worrying
of
phenomenon,
court.
especially.
They were procured by default because
Yeah.
when their judgments are procured
It means that there
in
was no
default
defense,
of appearance or defense, it simply means that we're sitting at the AG's department and we are not working.
Is it there are multiplicity of issues that we need to look at? You see, what happened and what perhaps may have instigated this whole debate is that because there was an error in the Woyomi matter, an error that government subsequently found out and admitted and is taking steps to address. Some people sought to take advantage of the situation and create the impression that the payment of judgments debts in and of itself was wrong. Perhaps there was not much understanding about this whole concept of the, people may never even have heard before that government has paid some debts that accrued out of a judgment. So it was important to put the issue in proper context. That there are things that happen that compel individuals to seek redress in court. And when the court so orders that they should be compensated or damages should be paid to them, government cannot refuse to pay it. Of course, there are instances where due diligence must be done to ensure that the monies that are being paid are justifiable. And then there's the issue of institutional reforms to ensure that we equip our officers with the requisite skills to be able to go the full hog to defend the interest of the state. There are cases like that. And then there are cases...
And government thinks, for example, that the ceiling that you have introduced is
Yes,
one of the
what
ways.
that simply would mean is that there will be broader investigation, there will be broader consultation on the matter so that relevant state institutions will be alerted as to their responsibilities in the payment of these debts. And then there's a situation where because of impunity, because of the flagrant disregard for laid down procedure, we end up with situations like this. In those instances, it is important that individuals who conducted themselves in a manner that has resulted in a situation where government has to pay debt legitimately are held accountable. For me, that is how the debate ought to be looked at. But another important point that must be made is that the integrity of public officers is paramount. You cannot have a situation where public officers are called upon by sections of society, indeed other political parties, for purely partisan purposes, to look at the truth and blink, to look at the truth and lie, simply because they claim that is how you need to protect the interest of the state. It is not in the interest of the people of Ghana or the country Ghana for public officers who know fully well the facts of a matter to go out and peddle on truths just because they are protecting the interest of the state. I find it very difficult to accept that kind of analysis that members of the MPP especially are putting forward. And you hear from the texters that, oh, why are you defending companies? Why are you not defending the interest of the state? Is it in the interest of the state for persons put in responsible positions to abrogate contracts unlawfully, and for subsequent government officers to come and defend them when they know fully well that what they did was wrong? That is the morale that the AAL and the Isofotton case brings up. So when you hear government officials or government spokespersons putting out the bare facts and stating that indeed we had a contract with the company, it is important that we appreciate that and not think that those who are telling desperate lies just so that they save their skin are the ones who are protecting the interests of the state. But finally, I think that calls for a commission of inquiry or some sort of investigation into this whole affair are well grounded. Indeed, I am aware that as far back as December, when the president first spoke on the Will matter, he indicated that he had asked SFO to carry out some investigation. I'm not too certain where they've got into with that investigation, but I'm sure a cursory check would reveal where they got into. It will help put this whole discussion in perspective so that going forward, we know what we have to do to avoid a situation like that. Now, there are instances where, whether we like it or not, contracts have to be abrogated. For instance, if a contract is awarded to a contractor to do a road, and that contractor fails to carry out the project, and there are legitimate grounds for taking it away from him and giving it to another contractor solely on the basis of competence, it will be grounded. I don't think that there will be any qualms with that. But when you take it away just to show where power lies, just because you have the power to do it and you do it, I think that it is problematic, and that is what we need to consider. But like Mr. Jugate said, I agree with him on that particular score. Once government exists, government will enter into contracts. There will be times when we need to abrogate contracts, but we need to be careful that in doing so, we do not unnecessarily expose government to such legal actions that result in the payment of some of the debts that we are talking about this morning.
What about the payments procedure?
Of course, the procedure too is important. It is important that's why I'm saying that it is important for us to have a holistic discussion. If it is a problem of a lack of capacity on the part of public officials, let us by all means boost their capacity to be able to do this. Let us introduce more transparency in the way that the payments are done. But let us not conclude that simply because monies have been paid, then something fraudulent has gone on. And the clearest example yet is the CP matter, when there was legal basis for what Mrs. Betty Modibiso did. But simply because the Will matter...
Where is the legal basis?
Oh, please, it is in this arbitral award. If you follow proceedings, you will know. Oh. But let us not even go there.
Seconds.
Yes.
Chief of Staff said they didn't authorize it.
But the law does not require that approval. It is
90 million euros,
please.
Okay.
Wow. Why are you behaving this way? Show me which law which parliamentary approval. Cabinet approval to be paid.
Executive
but the point I'm making,
I have to move on. I have to move on.
Tell me the law.
Ghanaians are listening.
Throw the law book at me here. Tell me which law authorizes.
So now it's about approval.
Exactly. But the point is that because one payment went wrong, let us not say that every other payment was wrong. And even in that one payment that went wrong, clearly there are steps being taken by government to address the situation and ensure that the interest of the public or the people of Ghana is protected.
Okay. Now, Mr. Bako Jr., you have groups like the Ghana Integrity Initiative and others suggesting that they do not subscribe to the proposal for a presidential commission of inquiry because, I mean, let's be frank, let's be truthful to ourselves. The commission will go into it and make recommendations. In the end, what will the recommendations be? Except to say prosecute this or take that action. So if we are clear and we know that people have acted recklessly, they should be attacked. The judges suggest surcharging of officials, especially where there is the suspicion of official collusion.
There's evidence of
the Auditor General made a similar recommendation. Is it in the 2010 report that officials who are responsible, deemed to be responsible for those things, must be surcharged. It's not a recommendation you can challenge or dispute. The Supreme Court one is also in the order. And call for presidential commission. I hope those making that call know the constitutional obstacles that will confront that particular investigations at the end of the day, whether those things could be used to prosecute. We know of the Ghana 50 incident, because they would have the status of a high court ruling. So the people may have to appeal at the court of appeal. We have that obstacle to deal with. Then there are certain cases, big ones, gargantuan ones, which are already in court. And for that matter, I'm not sure they can fall within the remit of a presidential commission. I'm not sure the commission would have the mandate to interrogate those issues, gargantuan ones, including the whatever one which is yet to come on the radar. I'm surprised.
But you put it on the radar for
no, I
quite
mean
some
in terms
time.
of judicial
You
radar.
published correspondence.
No, I'm not talking of the public radar, judicial.
Judicial radar. Oh, okay.
The police are supposed to investigate it.
Okay.
Whatever, there appears to be a conspicuous silence there.
But work may be
all of
going on,
us,
all
yeah.
we know, yeah.
But that's another very serious one. That one, I'm not sure. It's being criminally being investigated. So there, the presidential commission thing is already challenged in terms of proportionality. What can we bring and what we cannot bring? So it's a problem there. Otherwise, in principle, what's wrong with it? With the mindset that we are not going to play political football with. But you see, there are certain things, and all these things I've mentioned, even in our statute books, we have some legal remedies for them already. It's been a question of whether we are fair to ourselves and we are ready to do a very dispassionate, non-partisan dispensation of justice. But
I think that, for example, that the surcharging aspect is the most preemptive measure to take, proactive measure to take, so that if I'm a public official, then I know that my acts, if I do not guide them well and they are influenced by my personal gain, I may be surcharged. If I can't afford it, I go to jail.
But you could just before
Yeah,
you
sure.
come in. Even that recommendation, if adopted wholesale, may be problematic. Sometimes the fault can be yours, but you may not have benefited, as was the case in the quality grain matter, where the judge ruled that indeed he found them guilty of the offense, but then stated that they may not have personally benefited from it. So we need to be very otherwise we will be unfair to people when
these are options.
these are options
the
that we can
quality
consider.
grain, the judge's trust was to suggest that they were not being tried on charges of corruption.
Absolutely.
It was willfully causing
So they
financial
did not
loss. That's
benefit
an
from it.
extension.
Yeah, that's the thing. Yeah.
But you see, I was going to make a point that sometimes too it is, and I hope I'm not taken out of context, the kind of people we have at the AG's department or who head those departments. See, and I'm sorry, I hope I'm not mistaken for anything else. For instance, on what basis did anybody assume that the August 5th, 2005 concurrent approval given by the Central Tender Review Board amounted to a binding agreement if the person was well briefed or well informed with the procurement law? So it shows there's a deficit in terms of the training as well as the knowledge and the capacity of an AG's department. And no, they have all sorts of experts there. But perhaps, just like we are now training people in oil and gas because it's a new area, we may have to strengthen that area, you know, in terms of procurement, in terms of contracts, in terms of all those things. There are people there who may know this thing I'm saying better than I do. But why are we not bringing it to bear on the work? But somehow, maybe we need restructure, a comprehensive thing. Otherwise, see, you wouldn't have taken a letter written by Jumamenu or a concurrent approval given by Central Tender Review Board as a basis. And for that matter, we would not have reached where we are relative to the Wyoming palaver. The same with whatever, if you go into it. You know, and indeed, let me finish. What is it that happens to us as human beings? And we make certain mistakes. Is it self-interest? Is it sheer ignorance? What is it? The classic case being the Rockshell matter. I'll use it to illustrate and conclude. You enter into negotiations with this company, okay? The company's case began from 86 till 2006 when he went to court. He was seeking interest from to that time. We end up with $12 million as the settlement for him. He takes $5 million under the previous administration. There's a balance of $7 million. How is it possible that when there's a change in government, this same company will come back and say, look, I have some liabilities you need to fulfill. And he's giving $35 million. In addition to that $5 million, making it 40. And even we don't refer the interest payments which are taxable to the tax authorities. So he takes all the 40 and he's gone. I'm not talking of government supervising that. I'm asking those who have entrusted some responsibilities to, who work in various areas, Ministry of Finance, Attorney General's Department. What is it that makes it possible for a Ghanaian to ignore all those things?
Yes.
Sometimes because we all go look for government,
we leave those who are really the opposite. Yeah.
Thank you.
There
give
must
you a
be
little more
something
time.
wrong somewhere.
Now, Sami, I discovered that you also seem to subscribe to some of the proposals that are being made already. But again, and it's a difficult thing for me to make reference and to people at the Ages Department. Some of them are my colleagues, and I know that in school, I mean, we did our best. So to find them come under such a barrage of invectives for doing their work is difficult. But the aspect about relying more on external solicitors, is this something you buy?
I don't think it's a new proposition. We have tried it before, even in this the professional group thing. It's an attempt at seeking external opinion, second opinion. It's interesting that all of a sudden my senior brother Kweku Baku appears to have fallen in love with the professional group, because this same group, remember their recommendations on the EO matter. It was poo-pooed. When they said that they were
no, because you've mentioned my name, I don't know about any report issued by professional group on you. I have no idea.
Thank you. Move on, please.
And I've never spoken on it too.
I
defend the you.
But remember you poo-pooed the forgery and
but I have nothing to do.
The states.
Okay.
And I stand by it.
States
I
position
still
to proceed
stand
with
by it.
Can you
They
move on
did that job. That was a
without
very
the
funny
reference to
job.
Thank you.
Okay, thank you.
No, they did that job.
So they can do
So
it's interesting that when an opinion seems to, give a certain buffer.
Sammy, I protest.
Give a certain buffer to your
I
friends.
protest. I don't think you are
You
being
think
fair.
that it's an
not
expert
being
opinion.
fair to me.
But
my
when
position on
but
you
you
was
reacted to
based
him.
on the audit Attorney General's charge sheet, if you recall.
Do you know how that charge sheet came about?
No, but you see, you are being unfair to me
Thank you,
because I can
thank you,
impute as
thank
well.
you. So
I did not
let's
see
move on.
any group report from that.
Good.
That
Kweku, I
report
think you
there.
have
I
made
did
that
not.
point. So thank you.
No, but
If you can give me a
Sami, so
copy, I'll be
let's
most
stop.
grateful.
Let's stop the.
Don't worry, I'll
we
help
need
you
to do.
intercept
We're
one.
very limited time to go. So
Just give me a copy of that report.
So I think that the substantial point I was making is that it's a good effort to seek external support. Even in the CP matter, I do know that successive governments, the previous government and this government, still relied on external solicitors in the international arbitration. So that is a fair point to make. The other thing I want to introduce has to do with ensuring that we are also prudent with these liabilities. You would have observed that with some of these cases, it has been determined by the courts, but intransigence. Public officials don't want to respect the courts because they don't like the decision, so they refuse to pay. Then interest compound. Interest keep compounding. If you look at this letter here by Dr. Richard Anani on the 23rd of December 2008 on the CP matter, written to the finance minister at the time, he makes the point: the outstanding amounts due to the contractor on outstanding approved certificates at the local and foreign component as at 18 October 2002, when the reconciliation was carried out, are 6,176 old Ghana is coming to 617, and 7,892,704 Deutschmarks, whilst on certified interest up to 30th June 2002. So he gives the figure, no action. Then the interests are compounded. I also have here a letter by the Honorable Joe Gatti, 25th April 2008, on this same CP matter, where he was talking about the various projects, the Biriwa Takradi Road project. In the last paragraph, he writes, meanwhile, we should be mindful of the fact that interest on the amount is rising daily. The principal that was awarded by the International Tribunal was 24 million euros, 617,524.86, and interest was 8,828.405 euros. The interest which accrues daily daily is 8,575.93 euros.
Sorry,
daily.
can I see?
You know, this is
Just 1 minute.
That was Madame Betimo's concern
you know,
also
so
with the CP.
so sometimes we can cut our losses. That's the point I'm making. By reading the Dr. Anani letter and when the matter has been fully determined, let us not wait when they begin to identify our properties, garnishi accounts, place auction notices that they are going to auction our cocoa board properties in the UK, or the garnishi the Unifil account like CP did. Then we begin. Then we begin to rush, and then we pay 7 million euros to them before the previous government left office. Then we now have a situation where a liability, which if we had listened to the international arbitration and paid not more than 20 million euros or so at the time, 2006, we will not today be grappling with 94 or 101 million euros if you add the 7 million euros which was paid by the previous government. So that is one aspect to look at. The other aspect, the constitution, the commission of inquiry. You see, something because of the ruling by the respected Justice Mafusa on the Ghana at 50 case. If the intention is that we want to prosecute, then we must be careful. If we want to prosecute, we want to punish people, we want there to be, you know, as it were, a scapegoat, so to serve as a detriment to others in the future, then we have to be careful because except we don't bring such people as witnesses. But once they appear at the commission, then we will be in trouble. So there are all those aspects.
In respect of the Ghana at 50, my understanding is that is the instrument that was created, the commission.
Yeah, that's one of
problem
it.
Because it gave them immunity.
Yeah, but beyond that too, I've read the judgment. Beyond that too, he went into the 1968 Constitution, 78 one, and then came to the conclusion that Constitution Review Presidential Commission, are fact-finding. Their decisions are that of a high court, so they are enforceable. And that parties who have been affected will have to appeal. If they don't succeed, then you can enforce the outcome. So that because of double jeopardy, you know, so that is an aspect that has to be brought on board. But the text message, the back and forth from Honorable Martin Amidu, I'm happy that I spoke publicly. It's on record. Everybody has the. I have not changed.
You said you spoke the truth first. Subsequently,
I haven't changed.
you are lying.
No, the first time I talked about the petition. I talked about petition. You see, there's an attempt to draw me into some battle, you know, insults, youthful lies, and all of that. I would not fall for it. I would not insult back. It's not in my nature. I respect the former Attorney General. If indeed he thought that my call was that effect payment, you'd ignore the fact that there was a judgment which said pay. Even if my call was for payment and he found wrong with it, what did he do about it? Did he report me to the president? Was I sanctioned? Is it that now that you are out and you are full blown, I mean, so as for the NDC government, it was only Martin Amidu who is upright. He's the only one who is right. All of us, everybody from the president, everybody is out to commit gargantuan crimes against Ghana. He was the only upright person. Let the good people of Ghana judge.
You have been on Newsfile here on Joy 99.7 FM. You've also heard us across the country on our affiliate stations, streaming live also on myjoyonline.com, multitvworld.com, and also here via TV here, Joy News Channel. On
Samson, one quick second, just before you end, because there was a small 1 minute this thing to the CP. Because
you had a lot of 1
minute.
minute.
Oh, just, you see, with the CP debt.
Also ask for 30 seconds.
Oh, yeah, with the CP debt, it's very important.
Sorry,
Felix,
we don't have time.
I know.
We don't have time.
Yes, CP. It says CP will accept 95 million euros, okay?
In full and
then they said
settlement.
they will accept it if it would include a resolution on tax issues. The tax issues for CP, according to the Auditor General, are 140 million. What will the government do? We owe you 90 million, you owe us 140 million. If you even deduct the money, they owe us more. Why did the government of Ghana
You don't
go
calculate
and
it.
pay
You don't calculate
on that?
But you see something. But you see something. Why should we even
Betimon says,
Yeah.
Betimon says, yes, you can still go for
There's
it.
nothing wrong with that.
But when you have somebody's money, you say they
But you
should
see
pay.
something. The fundamental issue is
They
that
garnish
why
our
should
accounts.
the
We go and chase them.
fundamental issue is that why should we have created the CP matter? Why should we have created this CP situation and now we are crumbling over taxes?
Oh, look at that.
We shouldn't have.
taxes
We
and you
shouldn't
get
have
them
put
90
Ghana.
million.
We shouldn't have caused this in the
I
first
can't
place.
believe you.
We shouldn't have caused this. We shouldn't have caused
We have
this.
been told to chase
Today
the
we are
money.
crumbling over taxes.
Look at that. And they garnish our accounts.
Gentlemen.
But we there, we should go and chase the money.
Okay.
It's very sad.
Gentlemen,
Don't cause it in
I
the
trust
first
that
place. Don't cause it.
I trust that God has heard our prayers for a redemption from this judgment debt matters.